Hello, everyone. Good afternoon, good evening, good morning, wherever you're coming in from. How are we doing? Got a couple of chatters already here. Blanco, Cass, Rosawa, Rosara, Rosawa. Did I say that right? Was it Rosawa? That's pretty. I'm a little early. Hey, Baba Gadoosh. I am just trying to get on here because I wanted to go ahead and get us started today, get us rolling. We'll wait for everything to happen. I want to go over with you guys. They're not going to start today until 10:30 Mountain Time, which means uh, that is 12:30 my time, which is in just 4 minutes. And my time is this is a Diet Coke, by the way. This isn't a beer. I'm not popping open. Uh, my time is Central, and then of course it would be 1:30 Eastern Standard Time that they're going to be starting. So what's expected to happen is Miss Lori is going to rest. We think. She wasn't sure. She doesn't know. We shall see. And then, hey, Mark. And then the next thing was they've got to do the jury instructions, which I've got a little bit to say about that because I've got a couple of notes from when they talked about the jury instructions. Jury instructions are weird because we can't really know what they're talking about, but they had a conference and they had it on where people could actually watch and see. Hey, John Cooper, welcome in. Blanco. But we're going to go over a little bit of that. Then they're going to take just a 1 hour lunch break today. And then they're coming back at 1 p.m. their time, 3 p.m. my time, 4 p.m. Eastern Standard Time. And they're going to start the closing arguments. Lori says hers are only going to take a few minutes. I think that's so funny because we know that's not going to happen. And then we go on verdict watch, you guys. So let me just start. I'm going to start here and then we're going to move backwards a little bit. Welcome in everyone who's coming in as I'm reading. I'm not going to be able to say hello as you come in, so please bear with me. What's been updated so far by Nate, who is with East Idaho News. He's been in the courtroom since 10 o'clock, and he says that there was a big line out there today. There was a lot of people in there. Some flew in. A lot of people drove a bunch of hours to get there. And he said that also the Madison County Sheriff Ron Ball was also from Rexburg, was also there, Rexburg, Idaho. So he said Brandon Boudreaux, that's her next case, right? That's her next trial. He walked in and went into a private room near the courthouse or near the courtroom. That is all he's said so far. He said Trina Kay is at the prosecution table with her paralegal and Detective Nathan Duncan. Now, the defense attorney and Lori Daybell are not yet in the courtroom. So that was just now that he just updated that. He said that Kay Woodcock, Jerry Vallow, and Susan Vallow are all there. I want to talk a little bit about, but until they start rolling with that, let's go back over here and talk about what happened on, what was it, Thursday? Because we weren't up on Thursday because I told you guys, I'm like, I am not going to stream jury instructions. That's way boring. That's like listening to some of our most boring scientists get up and talk. And y'all know how I am about that. Hey, Dred, what's going on? Welcome in. Hey, Renee. Hey, Deb. Hey, Carolyn. All right. So what Nate said last week, a couple of things that jumped out at me was that they have officially set the trial date for May 30th for Brandon Boudreaux. And I think we kind of knew that already. It's going to start at 10 a.m. their time. So it looks like we're going to be very much on the same schedule that we've been on, maybe a little bit earlier. They're going to have a hearing on May 14th. I've got that in my calendar, so we'll be there for that when they stream it. And then again, at the end of May, the trial starts. So we've got a little bit of time in between. We'll have other things we're going to talk about. Plenty of other cases going on for us to discuss between now and then. But they were going over the jury instructions, and a dispute came up over the facts applying to the rule. Let's see. Lori made a comment about whether or not Charles had permission to be in the home when he was shot. Well, then Trina came up and said, "Well, yeah, but his name was on the lease, so it wasn't trespass." So they were like, "That doesn't mean anything. Can't use that." She also made a comment about one shot versus two shots. Pretty much didn't add anything she said to it. It seems like they're all in agreement over the jury instructions. He gave them the weekend to look at everything. And they did talk about the jurors coming into the next trial, where they said that the jurors would be screened through July 3rd. Trina said that Trina's the prosecutor. She said she would much rather have a jury expected to stay long but get released early. The judge says that would be twice as many trial dates as this trial was. And she said, yes, but we screened for 6 weeks and did this trial in 2. And there were 21 trial dates scheduled in this trial, and Trina did it in 7. So Trina said that's what she's asking for. He said, you can do what you want to do. My hesitation is if we all go all the way into the 3rd, we may lose a bunch of jurors on the 4th of July weekend, which is true because of vacations and stuff. And Lori said that she objected to not having her trial by May 11th because she wants her trial to start on May 11th. She wants speedy trial. And the judge said that the first trial was screened until May 15th, and 2 trials cannot be held at the same time. The state needs time to bring in out-of-state witnesses, and there are scheduling issues for the judge as well. Because remember, this judge is coming off this particular, he's on rotation. Judges rotate. So he's coming off this rotation, and he's got to go on to another one. So he's having to work this trial into his moving over. Because I think he said he had some training or something he was going to start before he moved over to the other rotation. So she's kind of stuck. They can't move the dates. So that's what happened last week. Not a lot. I mean, nothing to write home about, but just a few things. Nate said that today every seat is full, and several members of the public, he said there's about 24 of them, were turned away because there were no seats left. The defense advisory attorneys came in about 10:30. Lori's investigator is seated at the main defense table. Lori walked in dressed in a navy pantsuit. Oh, she's wearing that thing again. You think she's got that same flurry thing on again? She only had 2 suits through the whole thing, black and navy. She's carrying a paper document holder, and the judge just came out on the bench. Judge said a few modifications have been made to the jury instructions, and the judge's assistant just reminded someone in the gallery that eating is not allowed in the courtroom. Somebody brought snacks. You can only do that when you're watching it here with us. We do snacks here, don't we? We love snacks. Okay. I'm briefly reading over what you're saying, Dread, but I have not seen that yet. But I'm sure it'll come to it. Oh, gosh. Is it old or new? It's a cult case. I did a bunch of podcast listening this weekend. And it was on cults and stuff. I don't know. It's reading into, because I was so ignorant about this religion, that this Mormon, this Latter-day Saints. I wasn't sure about no, they're not. Are they? Yeah, they're Latter-day Saints, right? LDS. So there was a lot of questions I had about it. So I was trying to kind of understand. I don't want to know their religion. I just want to understand a little bit more about it so that I'm kind of better when I'm talking about this stuff. But I also, once you start going down that road, then it leads to Scientology, which I'm very well aware of because I have researched that a lot. And then we're going to get into other cults. But yeah, I do love doing cults. I was thinking about that. I really do love talking about the craziness in it. It's just like true crime. They are crimes, right? Welcome in, Bama. Let's see. I just got a message from Laura. Let me see. She might be running late. Yep, running late. Oh, she went to the doctor today. All right. Is Patty here yet? Y'all, she's not here yet. Y'all, it's Patty's birthday. Should we all sing when she? I'm gonna say 1, 2, 3 when she comes in. We'll all start. We'll say surprise. I'm just kidding. I promise I'm not drinking today. I'm just in a good mood. I haven't been around y'all all weekend. I got to let out my craziness when I get online with you guys. I've got a bunch of stuff for us to watch today. Well, I got a lot of stuff for us to listen to. So I've been clipping a lot from the Idaho trial. I've even gotten into some of the stuff with Chad's trial a little bit. You can send them to my email address. If you go to the description of any video that I have an email address in there, Dread, and you can send me anything that you'd like to send me. I missed you too, Cass. I did put up a couple of things. I wasn't going to put anything up on Easter, though. I didn't think that would be right. So, but did you guys have a nice Easter? I call it Resurrection Day. Did y'all have a good day? It was nice weather this weekend over here where I was at. Very nice weather. I have Law and Crime. Oh, here, let me show you guys. I've got this pulled up just so you know. We're not going to miss anything. I've got LNC right here. So when it goes on, oh, I got to take that down. When it goes on, we'll be able to hear it. And we got a picture. Let's put Charles up there at the top left. Okay, I've got so many updates for you guys on the different cases and whatnot. And I wanted to go over them with you guys because we probably have another 20 minutes before they even stream the start of today's hearing or trial. So let's get into this. Let me see how much time I've got on these things. Okay, first off, Marcella Chedester. Remember the lady who ran into the boat club, Swan Boat Club? Well, and remember her little walrus prosecutor? Now, I know some of these I'm getting late. I'm getting these updates late to you guys. I know this. I've been sitting on them, but it's just y'all know how I am. Anyway, Walrus Man was fired. And we don't know why. He doesn't know why, but I thought that was so weird because all she has left is the sentencing. So I don't know if it was something having to do with her speaking at the sentencing or not, or somebody speaking on her behalf, or him not doing enough work to get more people there to speak on her behalf. I don't know. I was trying to think, like, what would cause somebody to fire an attorney after everything's done, except for the sentencing part? I mean, that's kind of, it's just very odd to me. Very odd. Unless she just flat out got sick of him or something. I could see where she would get annoyed with him, but I don't know. She sat there for days letting him do his thing, and she never, he started off as the nightmare, and she didn't say nothing. She didn't say anything in the middle of the trial. I guess she was afraid to do it during the middle of the trial. So what happens, guys? Can you fire an attorney during the middle of the trial and be assigned a new one? And what happens? Will they delay the trial? I don't think they will they? Maybe she's going to have this new attorney come in and reappeal for a new trial and say ineffective counsel, and we want a new trial. She's going to pull a Jennifer and James Crumbly. Doesn't mean it's going to work because it's not working for them, but so anyway, that's the latest on her. The other thing, which I actually have a video for. Why is this only 1 minute long? Okay, hang on. That's not right. Please hold. I've lost my information. Oh, jeez. Oh, golly. I lost it. I lost the information. Okay, the other thing was Nikita Kassup. That's the other one I want to talk to. Remember the Waukesha teen? And y'all were saying that he had he was making threats against the president, and I was like, no, that's the other guy. I was wrong. You guys were right. I did not see this part. This has been up for a little bit, but I thought we'd watch it. Am I wired today? See, here's the thing. It's early. I've been waiting to go on with you guys. I get like this, by the end of the day, I'll be snoring by the time I sign off. So I just have my ducks in a row, what I want to talk about. Normally, I don't know what I'm going to talk about. Today, I've kind of planned it out a bit. So, Mark, settle down. I'm going to put you in timeout. Laura's going to be here soon, and when she gets here, we will put you in timeout. Not putting up with you today, Mark. I'm just kidding. Anyway, how long is this? Because I don't want to start it if it's too long. Oh, it's not long. Apparently, I didn't do a very good job of this. So this is the kid from Waukesha. Let's watch this really quick. Because he had like a manifesto and everything. Little psychopath.
A calculated plot that actually dates back months and could even be considered part of a much larger attack. A federal search warrant says Kassup wrote a manifesto calling for the assassination of President Donald Trump to start a revolution to, quote, save the white race. The warrant says Kassup talked about his plans with other people who encouraged him and helped him.
Months before prosecutors say he killed his parents, agents with the Federal Bureau of Investigation say 17-year-old Nikita Kassup was conspiring to potentially kill President Donald Trump. A newly unsealed search warrant shedding light on phone and internet records detailing the teen's plans. The warrant says Kassup was engaging with a group called the Order of Nine Angles, a known neo-Nazi racially motivated group. In a 3-page document called Accelerate the Collapse, which the warrant describes as a manifesto, Kassup referenced getting rid of the president and perhaps the vice president to create chaos with the goal to save the white race from Jewish-controlled groups.
Don't these children have enough to do these days? Do they not have enough to do? I mean, first we gave them video games. That wasn't good enough. We need to send them back out in the woods and let them play outside. And don't let them around electronic devices anymore because it's rotting their brains. We didn't have these problems when we played outside. When we come home from school and we go outside to play, all we ever got in trouble for was riding our bikes too fast or not coming home when it got dark, that kind of thing. These kids are they're just let loose. I don't know if it is their parents. Hey, Shraddha. I don't know. I think sometimes it is. I think sometimes it's the kids they hang out with. Some kids, their parents, I just kind of wonder how much control parents have these days when they're up against so much on the internet. Like, just everything is at their fingertips these days, the kids. They know how to get around it. They know how to do what they want to do now. And you couldn't do that before. Parents were able to watch you. If you were doing something wrong, you were physically doing something wrong. These days, all you got to be doing is sitting in your room being quiet. Oh, Blanco, you don't bore me. That's not what I was saying. And you know that. No, I get tired listening to these trials. Like when the scientists come on and the medical examiners come on, sometimes I get sleepy. And it's just because that's not my niche. That's just not the part I like. That's what I mean. And the chief, love the Cheeto and Cheeto. Okay, y'all don't start with that. I knew it was going to get political when I played that. Don't start. Okay, first of all, let's not call our president a Cheeto. Y'all need to stop doing that. Secondly, I don't want to start like talking about race and stuff either because I hate that. Honestly, though, I was watching some stuff this weekend that made me so enraged. Okay, I'm going to start talking about it anyway. Okay, the kid that got stabbed I know you guys have seen this. You know the kid that got stabbed at the track? Well, I don't know the details of it, but what I did see was somebody did an article or did a thing on, it was a video. Somebody did a video on the fact that when they set up the GoFundMe to help this kid get out of jail, this is what just blows my mind and freaking annoys me so bad, is that people will just throw money at the guy that killed the CEO of United Healthcare and the kid that stabbed another kid. Let's just throw money at them. But when it comes to helping our veterans, there, we don't see anything there. I get so angry about stuff like this. But it's beyond dumb, because now the kid who stabbed the other kid, his parents used some of that money from the GoFundMe to move into a gated community, and they're in this brand new nice house now, and they've said it's for their safety, so that they feel more safe, because they were worried about people coming after them. Now, can you believe that? Is that not ridiculous? So that's where your dollars went, people. Anybody that sent money in, that's where your dollars went. And this kid over here I'm not saying our healthcare system is great, but I'm also hearing things about like that United Healthcare guy. He was in there. He worked a lot with trying to work the system where it was more in favor to the policyholders and whatnot. So, I'm just, okay. So Miss Kitty says, no, they didn't. They can't touch that money. And the escalator is the 23 Escalade, so that they've had it for a while, or they think they had it for a while. So they're not in a new home. Miss Kitty, they're not in a new home. Yeah, somebody says they bought an Escalade. I don't care if it's if it's an older Escalade. I don't care. I mean, they're using the money for something other than this kid's defense. The money was for his defense. This is why I won't promote a lot of GoFundMes, and this is why I won't hardly send any money to any GoFundMes, because people are so manipulative these days. Do you think the United HC's press company would accept or reject his claim? Do I think his claim for which claim? It doesn't. That's the insurance company making that decision on the claim. It's not the United Healthcare president alone. If you want to go after United Healthcare, you need to go a lot higher than where he went. And it's not just one person. It's a big old group of them. And if you're going to do that, you might as well go after the other ones. God, don't go after the other ones. I don't mean that. But I mean, you know what? It's so stupid. It's so stupid. You can't commit a crime to make your point. You can't do that. You'll never see me have a GoFundMe. Watch, tomorrow I'll have a GoFundMe. No, I'm not going to do a GoFundMe. But I do have a Venmo if you'd like to donate. No, please donate for my content creation. That Germany character is running a scam business, and they have money, and they help them get that place, but they technically cannot touch the money from the defense fund. Oh, I see what you're saying. There's somebody helping them. Okay. I got you, Miss Kitty. I'm kind of on the outskirts of that a little bit. But yeah, it's Dominique. It's the state that dictates what an insurance company can and can't do. This is true, Doxy. There's a lot involved in it, and it's all legal documents. I mean, there's a lot of people surrounding the insurance companies. It's not one person. Kerry's new GoFundMe plan. Thank you, Mark. Woo, thank you so much. Get me some wild Buddhas on that one. That's a good point. Susan B said she thought that GoFundMe wouldn't allow funds for violent crimes. Let me put this back up, you guys, so we'll have it in the background. I didn't know or even think about that, but that is a very good point. But I guess the way around it is that they're allowing them to do it to pay for their defense, and they're somehow, and maybe that's what Miss Kitty's talking about. Hey, Barbara. So, yeah, I don't know, you guys. I just think it's insane. And then, so anyway, back to this Nikita guy. I took a side road there. This kid had too much damn time on his hands. Why do you need to? What apparently he's a really smart kid. He did well in school and everything. But the money, the reason he wanted to let the parents out of the picture was because two reasons. He needed the money. He needed their money. And also he didn't want his mother disappointed in him. So, we'll just offer first. Sorry. I have a sore throat. So this is where we are. Okay, let's see if we got some audio yet. Not yet. But we do have the courtroom. All right, yeah, we'll probably be starting in about 8 minutes. If you're just now coming in, you have time to go back to the beginning of this video and listen to the updates that I gave on this case or this trial. I saw that Adolescence movie because yesterday I turned on Netflix for a little bit and was flipping through, but I have not watched the show itself. But I did it was like the first thing that popped up on Netflix. Is it any good? We need to know. We need to know these things. I started watching Passion of the Christ yesterday. I thought that would be good and appropriate. And then I forgot that it's all in, what do they call it? Captions? No, subtitles. And I was like, ugh. But plus we had company and people were coming and going. I couldn't really watch it. Yes, please go back to the beginning and listen to the Princess Rant. Thank you, Mark. I don't know what I thought it was. I really didn't get, I don't know. I hadn't even looked at it yet. I think I didn't look at it because I wanted to move. I was looking for a 2-hour movie and it was, isn't it like a series or something? And here's the thing. I was looking at do you guys ever watch movie trailers on YouTube? You know how they'll have these different channels that have movie trailers, like the latest movie trailers in 2025 or whatever. I was so disappointed. I don't think there's anything good coming out. Oh, I have watched the Passion of the Christ before. I just thought it would be good to rewatch it yesterday. But it was just, there was too many people coming and going in the house. What else was I going to tell you guys? What other notes did I have? Oh, do y'all know anything, the people that were following this trial well before I started following it? Mark Means is the one that represented Crazy. George, what's his name? In Florida, who shot Trayvon Martin. And I guess he was supposed to be working with Chad at first, but he ended up not representing him. What happened with that? Does anybody know? I found that in my research this weekend, but I didn't follow through. I made a note to check on it, and I never got to it. So again, if you're just now coming in, the schedule for today is we expect Lori to, make this extravagant rest. Zimmerman, thank you, George Zimmerman. She's going to extravagantly rest her case, the defense is. And then they'll do jury instructions, which I guess what they're going to do is bring the jury in, do jury instructions, or let her rest, and then send the jury right back out to finalize jury instructions, unless they do that this morning before they let the jury in. And then by 3 p.m. Central Time, they'll have the closing arguments begin. And they are going to take a 1-hour lunch today. But don't you kids worry. I've got plenty of clips for us to listen to. Plenty of stuff ready to rock and roll. What is her closing going to be like? Well, I was thinking about her opening. And the evidence will show. And the evidence will show. And the evidence will show. Well, I feel like this time she's going to be maybe a little bit more comfortable in the courtroom. So she'll probably be a better speaker this time around. Not as nervous. But I still anticipate her saying, did the evidence show? Did they show this? Did the evidence... That's kind of... I don't know what she's going to do. Sometimes she surprises me and does something really smart. And I'm like, oh, okay. You wasted a lot of that on crime, Lori. You could have been a real go-getter in life. Let me do an update really quick. See if Nate's got any special news for us. They're copying the jury instructions now, so I guess they already got them done. Okay. So they already took care of that. Lori asked if the interview that was admitted can be replaced with the entire interview. Judge says, no, Lori. He didn't say that. He just said no. He says there is a significant amount of hearsay in the interview. And Judge says, anything else? And Lori is clearly irritated and responds, that's it. And then at 10:40, Lori claims that the prosecution said that they were admitting her entire interview. Well, I guess I should have read this part first. Her entire interview with Detective Duncan. But the actual exhibit is around 20 minutes, far shorter than the actual interview. Lori said this could create a problem if the jury believes it was the entire interview, and the judge says that the state has rested and this issue could have been raised on cross. So, Inklin is her name, not Duncan, Inklin. So at 10:30 this morning, she came in and she's like, I have 2 issues I want to raise. She asked how the alternate juror process will go. She asked... The judge said there's 2 numbers which will be drawn after the closing arguments, and those people will be the alternates. 12 then will go back and deliberate. If one of the 12 is unable to deliberate, an alternate will be brought back. Lori has another question about an exhibit, and this is when she starts asking about her interview with Detective Inklin. Is she talking about the whole portion where she just sits there and doesn't move? She just sits there and waits for the woman to come back in the room. Y'all remember us watching that and how long we had to forward? She doesn't want the snippets played. She doesn't want to be edited. Lori does not. Look at how she treated Keith Morrison from Dateline. She does not like to be edited. She is not having that. So she's ready to get this Brandon Boudreaux trial done and over with so that now she can go back to the prison and advocate and become an advocate for all of the women over there. I just was listening this morning to something on News Nation about, I think it was California. If you guys watch News Nation, you'll know what I'm talking about. That prison that's been closed down, and it's not just one. We know it's more than one, but it was a female prison that was closed down. Oops. Might have to talk about this later. Yep, she's wearing that same jacket. We don't have any audio. I have the audio on, so we'll be able to hear it when it comes on. So the female prisoners were all being subjected to all kinds of physical abuse, SA, by not just the guards, but by the warden and by the chaplain. One woman says she has not opened her Bible and cannot open her Bible to this day because of what happened to her and that chaplain. Can you believe that? I guess I can believe it, but anyway, they had a hard time proving their case and they had to go, like, it went on for a really long time.
All right, we're on the record, State of Arizona versus Vallow Daybell, CR 2021-001704. Why don't I have the state announce? And the defendant?
Vallow Daybell.
All right, we met on Thursday and went over jury instructions. In the meantime, since Thursday, there was a few modifications sent out. We put drafts on your desk this morning. Last week, let me just pull up that email. Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence. So I added that this morning as well. Have you had a chance to review the latest draft, or do you need more time? We told the jurors to be here at 11, so we have time if you need more time.
They muted it. By the way, I haven't forgotten about promising to do something on Pam Hub for you guys. I've just been working on it. I have a vision of what I want it to be, and I just can't get there with it yet. It's in the works. She's not even turning around and looking at her legal, but I guess they're looking at a copy as well, her
Any
legal.
other record you want to make on mere presence?
Oh, yeah.
All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm.
Anything else?
The presence of an accomplice.
Okay. And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from Mexican.
Okay. All right. So how many jurors? You can go ahead and print out.
Your Honor, I have two issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing two numbers out of randomly out of a container.
Okay. And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me what's 286 is, whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected.
All right.
The state redacted out the beginning, the end discussions of hiring. That would be hearsay or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors in all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out.
Yes,
But it's just more or less what was played in during testimony.
correct.
Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she testified that it was the full interview?
I don't know. It's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that, but the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions. So either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my advisory
testimony.
council checked the FTR, and that's exactly what was said. That was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes.
Okay.
It is the full interview. The defendant talks to the detective in the beginning about Kylie, does not include that. She talks to the detective at the end about Kylie and victim services. It doesn't include any of that. She's sitting in a room for I don't know how long while Kylie's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the states closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was,
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Tylee said or did or didn't happen, the hearsay parts were, the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our exhibit 20, the defense's proposed exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No,
Why not?
your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that. Anything else?
That's it.
All right, we're getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
Oh, okay. So she's going to come, they're going to come back. She's going to rest for the defense. Then they'll read the jury instructions. Then they'll send the jury out to go have lunch and take a break because they're going to need it. Because when they come back, they've got to listen to closing arguments and then go into deliberations. I have a couple of things I wanted you guys to listen to today, but all the things I want to listen to are pretty long. So I don't really want to start anything right now until we have like a longer break. Would you guys want to listen to Chad Daybell's daughter testify? Or I have a neighbor of the Daybells also here that I was going to let both him and his wife, I think, both testify. I haven't listened to it yet, but this is in Lori's case. This is in Lori's trial. So it would be in regards more to not so much Chad or not so much Charles Vallow, but it would be more in the Tammy Vallow death. So it's a little off topic, but same defendant. Oh, and then I also have Charles's mother. That's another one that I have. So yeah, there's a lot of them. So you guys just let me know in the comments what you prefer at lunchtime, and that's what we'll listen to. Is it a 55-minute interview? Well, it wasted the jury's time, Lee. They're not even there yet. They are not. Once again, we have jurors late to get here. This has happened every day. I'm reading y'all's comments. And the judge is going to head to the bar after this is all over. Yeah, no doubt. She can't claim ineffective counsel. No, she cannot. She's not happy because she's not getting her way on a lot of things. And I think she didn't get the answer she wanted on Friday or Thursday. Oh, you don't want to listen to his daughter. Okay. I wasn't sure. Oh, are they a disgrace? See, I haven't heard those yet. But it's my choice. Okay. Well, they should go to timeout, these tardy jurors. I can't believe they're making everybody wait on them. I mean, we're already having to wait 30 minutes for the stream. I don't know which daughter it is, to be honest with you. I just saw that, and then there was a neighbor that I wanted to hear what they had to say. Sounds like they were friends with him. But I got the impression, just from the little bits that I heard about the Chad Daybell's kids this weekend, was that they said their mother was all about dad being this great person or whatever. Being this prophet. She agreed with it. Oh, are you talking about the docuseries on which one? Which docuseries did you watch, Susan? I started watching the one on Richard Allen. I didn't think I'd get anything out of it, honestly, because I just feel like a lot of what we need to hear is it's not. I think there's a lot of this underneath everything that we're not hearing about with that case. I am one of those who believe that he could possibly be the wrong guy. I don't know I am not going to stand up and put all my money on it, but I just feel like I have doubts. Yes, the jury instructions are currently being copied for the jurors. Once they arrive, if they would get here on time, that'd be great. And once they come in, then Lori will tell them that she's going to rest. Let's hope she doesn't try to give the jury a blessing. Let's see. One of the guys that was on testimony for her last trial. He made a comment that I thought was hilarious. He's like, "Well, he's like, what a blessing? What they give you a blessing for?" And he said, "I don't know. They throw them out like they're potato chips or something like that." They have a blessing for everything. Okay, there's something going on right now, but I don't think I should read it because you guys need to enjoy it when it comes on. So he's reading the instructions right this moment. Okay, so she does rest. She doesn't give him no stand up, no twirl around in a circle, nothing. She just says, "Yes, we rest, Your Honor." And they started reading jury instructions about 20 minutes ago. In lifetime, that is. Let's see. We could start some of this. As soon as we do, they're gonna come on though. I know that'll happen. I don't have any gosh, I have no great news for you guys today. Oh, what do you guys think of this? You heard about the Pope, right? I mean, that's all that's on the flipping news. Not that I'm, trying to say anything bad, but I'm just saying that's all that's on the news. That and oh my gosh. Oh, and Kristen Stewart got married. She married Dylan Meyer in an intimate ceremony in an LA home. This is page 6 news. Yes. Her she married another female. Who is like she looks like a model. It's hard to tell. No, she's got tattoos all over her. What happened to Kristen Stewart, you guys? She was so much better when she was Bella. And she was with what's his name? Progressive is not necessarily a great thing when you talk about religion, but I do know what you mean about him being progressive as far as this last pope, as far as the things that he would do that kind of brought himself off the pedestal to be more with the people and to be more outreaching, I guess. I guess that's what I'm trying to say. But progressive in a bad way could be like we don't need a woke pope. You know what I'm saying? Because woke don't work in religion. It's just woke. Well, woke definitely don't work with the Bible. You never liked Kristen Stewart? Well, I'm not saying she was the best actress in the world. I've always kind of wondered about that. I always wondered why they picked her for that part because I was like, wow, okay. But yeah. You did go to the Vatican before? Yvonne says, yeah, that's what I meant. Okay, I got you, girl. Oh, about prosecuting bad priests, yeah. What else is going on? There's an FBI warning about texting. Wait a minute. What does it say? It says that they told when FBI and America's Cyber Defense Agency warned Americans to stop texting, it created one of the viral text stories of 2024, prompted by Chinese hackers marauding through U.S. networks, and advice was to use fully encrypted messaging at all time, which is SMS texting, is not. Okay, that's tech talk. That's hacking talk. I mean, it's Forbes. What do we expect? Do we really expect to get a lot of good news out of it? Oh, that El Paso Walmart shooter, Patrick Crusius, whatever his name was. He pled guilty today, and he got life without parole. Good. What else is going on? Oh, okay. Oh, there's a glitch at Hollywood Casino at Greektown, Mark. I don't know what it's about. The U.S. asked judge to break up Google. What is that about? Everything else on there is all about politics, and y'all know we're not going to talk about that. Oh, and you know what else they've got? The what's his name trial starting too. The producer, the retrial for him. Oh shoot, what's his name? That guy. Lots of movies. Dang, I can't remember his name. I guess I should look in the chat because you probably saying it. A glitch. Yeah, a glitch. Weinstein. Thank you, Susan. Weinstein. So I guess he's going back to trial. But are these different people? Are these different complaints? I think they are, right? So his last one got thrown out or something? So Google could be a huge monopoly, I love the way you say that, huge monopoly, and something needs to be done about it. But what about Apple also? Because Google, if you're not aware, is YouTube. YouTube is Google. So every ad you see in YouTube comes from Google AdSense. We content creators get paid through Google on YouTube. Oh, you spelled it? No retrial. It's a retrial. Okay. So yeah, I don't know. And then I heard about Mark Zuckerberg. They're trying to talk. They're trying to say that he is trying to get in good right now with the president, and that he was at one point trying to get in good with the Chinese or something. That he has a whistleblower that was up talking. I don't know. I watched a little bit of that, and they said whatever's going on, he's totally involved with it, and he'll say he isn't, but he is. I know that's not very informative, but that's about what I took away from it. All right, what else is happening in the world of crime? We've got nothing on the Courtney Clenny front. We've got nothing on. Well, the latest on Corey Richens is that it's been pushed back because her attorneys are not happy. Remember, she was crying at the last hearing. She didn't get her way on that. And then who else do we have? Remember the guy that impregnated the 16-year-old girl, and then he took off with her and she ran away with him? Well, they caught him. We know that. I think I told you guys that. He's going to be in trial. He's going to be in court. On Wednesday, this Wednesday. If they stream it, I'd like to see it. They're also going to be doing the sentencing for the 4th of July parade attacker.
All right, we're back on the record. State of Arizona versus Daybell, CR 2021-001704. The parties are present. The jury is not present. We'll bring in the jury.
You saw Shabusiness attack another attorney. That was last week, though, wasn't it? You're not talking about this week. Did she scream WWE when she did, when she did it? Evil mother trial, unknown date. Okay. If it's a baby or a kid, we can't do it. Seriously.
All right, please be seated. The jury is present. Welcome back, members of the jury. Last Wednesday afternoon, the state rested its case, so now I'll turn to the defendant.
The defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions.
One of the jurors was like, "What the heck? Awesome. Let's do this." Get your pens out, kids. It's time to rock and roll.
Are we one? Oh, nope, we got it. Okay. Jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof. 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense, physical force. A person is justified in using or threatening deadly physical force in self-defense if the following 2 conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count 1, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following 2 conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and 2, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that 1, physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, or 2, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and/or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and/or deadly physical force. However, physical force and/or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and/or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and/or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person, or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict, count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Vallow Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All rise for the jury.
Okay. That wasn't so bad. Thank you, Miss Barbara, for your super chat. Pretty rainbows. All right, let me close this volume off here so it doesn't annoy me, because y'all won't hear it, but I will. Yep, first off, everybody, we have to sing happy birthday to Patty. So y'all start singing right now. and I'll conduct you because I'm not going to sing. All right. We have the neighbor from Chad Daybell's house that I would like to listen to, if you guys do not mind. This was in Lori's Idaho trial. Thought this would be a good way to fill the hour void, so we're not just sitting here staring at the court outside the courthouse while we're waiting for it to come back on, and you guys can chat amongst yourselves. Plus, it helps us also get more familiar with the case. Remember, we still have another trial coming up at the end of May for Lori before this is all said and done. And who knows, by that point, I may have gotten you all the information that is out there on this case. I know I'm really slow at getting it out, but I'm really trying. I really am. So, happy birthday, Miss Patty. We understand if you can't stick around. We know you might have big plans today. Sounds like you do. And welcome back into the chat, Miss Laura. Glad you're back from the doctor and that everything went well. Patty, I told everybody that when you came in, we were all going to jump out and scream surprise, but apparently nobody heard me. They just weren't paying attention. It didn't happen. Sorry about that. Not very coordinated, are we? Okay, let's get to this other thing. They're still in the room, though. Hang on. What'd he say? I'm going to back up a little bit and hear what they said.
It's defense 20. No, it's defense 20. It's defense.
Well, it's got numbered.
On different ways. Oh, it's going to be 200 and something. Okay, yeah, give me a second. I'll figure that out. And should we put it on a CD?
They're just talking about
Anywhere from 256 to 272. You'll have to figure out which one it is. But we can clarify that. Might have to look at the actual exhibits to determine which one it is.
they're talking about jury instructions and
Gentlemen, we're going to ask that you take all of your belongings with you for lunch.
Anything else?
That's all, Your Honor. So,
Remind me to clarify which one it is when we get back from lunch, but your staff can look at or your team can look at the
There's Colby.
exhibits.
there went Colby. He just walked out. What I was going to say is maybe they're talking about the jury. What is it? The thing the juries fill out, jury questionnaire, but also they're talking about the evidence and how they would present it to the jury, like hand it over to the jury, I guess. I don't know. I don't know. I just had a thought. And one thing that Laura reminded me to tell you guys, and I did forget this, what I was going to tell you and what I said earlier. On last week, they basically they reminded Lori that Alex, Tylee, and JJ should not be mentioned today in the closings since nothing was covering them and they can't testify and the jury might wonder about where they are. So, I mean, that's kind of I guess we kind of all knew that, but he did remind her about that. All right, let me go over to this. Put up my little mask thingy. A different one than we normally do.
Did you listen to in any way or review any of the testimony that's occurred in this case since it started at trial?
No.
All right. While you're testifying, please talk right into that microphone. Please use an audible or verbal response to any question asked and try to avoid speaking over the top of anyone questioning you. That way we'll keep a clear record. With that in mind, Ms. Blake, you can inquire on direct examination.
Thank you, Your Honor. Would you please state your name and spell it for the record?
Todd Gilbert, and TODD GILBERT.
Do you know an individual named Chad Daybell?
Yes.
And did you know an individual named Tammy or Tamara Daybell?
Yes.
How do you know them?
Mainly, I knew that Chad was an author, wrote books, and when we moved into the area, we got to know him because of that reason. And of course, Tammy was his wife, and so that's how we got to know them.
And was there one of the two of them that you interacted with more often?
Yes, Chad.
How often would you see Chad?
At least once a week, sometimes in the yard, most of the time, at least once a week at church.
And I may have missed it, but did you indicate when you'd moved to into Chad's neighborhood?
Oh, it was March 2017.
Did you meet Chad and Tammy fairly soon after moving there?
Yes, it was within a week.
Did you see Chad outside of church?
Sometimes, not real often, maybe mowing his lawn or something like that most of the time.
And you indicated you knew that Chad was an author. Had you read some of his books before?
Yeah, read some of them, yes.
Did Chad ever discuss his religious beliefs with you?
Sometimes he did. Sometimes we talked mainly about the books that he had written, some of the stuff that he'd apparently, dreams and visions that he'd seen and how they related with some of the characters that was in his books.
And when you say characters in his books, was it your understanding those books were fictional?
Yes, he said they were fictional, patterned after his visions.
Did it appear that he was trying to teach you things or just share his beliefs?
At first, he was just sharing beliefs and just discussing his books. As time went on, he was pushing more that way towards teaching things towards the end there, or 2019.
And did the things that he was trying to teach you resonate with you?
If they were standard LDS church doctrine, it did. If they were not, I was kind of sitting on the fence. I don't know on that.
So you'd listen to him, but you didn't necessarily hold those
Right.
same
I
beliefs.
didn't say usually one way or the other.
Do you recall a time in approximately February of 2019 when Chad came to your residence?
Yes.
And do you recall him making any kind of a statement that stuck out to you?
Yes, he made the statement as he was leaving that he says, I don't know if I should tell you this or not, but I've seen a vision that Tammy's going to die and move on before her 50th birthday.
Did you happen to know how old Tammy was at that time?
I didn't, but I figured she was around 47, 48 area, I thought.
And at some point, did you learn of Tammy's passing?
Yes. On the morning of October 19th, 2019, I would usually get up early in the morning and exercise. And so when I come upstairs at around 7 a.m., Chad's daughter had just called Alice to tell her that her mom had just passed on. And so that's when we found out about it.
Did you end up going to the Daybell residence that morning?
Yes, we went there around 8:15 to 8:30 area.
When you got to the residence, did you make any observations of Chad?
Yes, he seemed like he was businesslike, more so than someone had just lost their companion, his wife, and that things were all pretty well planned out, ready to go for the funeral.
Did that seem odd to you?
Yes, it did, because usually you're mourning more than that if your wife passes on as a surprise. She surprises you.
And you said you arrived there, and correct me if I'm getting this wrong, but around possibly 8:30 that morning?
Yeah, yes.
And so she had just been pronounced dead shortly before that. Is that correct?
Yes.
Do you recall Chad making any statements to you that day or having any conversation with him?
Yes, he referred to, I said to Chad that I'd forgot all about him telling us that she was going to die until it actually happened. And so I said to him, well, man, I guess it happened. And he says, yes, it did. He turned his back away from his kids that was there so they couldn't see him, and kind of whispered that to me, that he said that. And that's probably the biggest thing that I remember that day.
And when you asked, so I guess it happened, were you referring back to the vision he told you about that Tammy would die?
Yes.
And you said he turned away from his kids. Did he indicate if he'd ever shared with his kids that their mother was going to die?
He did say that he had never mentioned that to them, and I don't think that they knew it.
Do you recall if he told you anything regarding how Tammy had died?
He mentioned that she had got up about midnight, had a coughing spell, and threw up in the bathroom. And she went back to bed, and he had figured that she had died around 2 a.m. He mentioned to us that he thought she had an embolism, and that she had passed away around that time. And at around 5:30, 6 a.m. that she had fell out of bed, and that he wanted Garth to come and help lift her back up upon the bed, and that she was already dead at that time.
And had you made observations of Tammy? Would you see her at church as well?
Yes.
Did you ever notice anything with regard to her appearing to have failing health?
No.
Did you make observations of Chad and Tammy together when you would see them?
Yes, when we first moved into the ward, they sat very close up to the front and was together as a family. As time went on, especially from first part of 2019, they would slowly move them back further towards the back. And so about June of 2019, they were almost clear to the back. They seemed like they were a little distant from each other from what we had noticed before, and that Chad was talking less to me about stuff, and that he just says that people that talked about preparation was kind of getting a little old, and so everybody's taking a break.
And on the morning of October 19th, 2019, did you end up leaving and coming back to his residence that day?
Which day was that again?
Oh, on October 19th, the day of Tamara's death.
Yes, we asked them if they wanted breakfast. So we went to McDonald's and bought breakfast for them and brought it back. And at that time, there was more people that had arrived from the ward to give their condolences. And so we just left the food on the kitchen cabinet, and Garth said that was okay. So, and then we left at that point.
At some point, did Chad talk to you about not staying in his residence, that he was going to move?
Yes, after we had been to the funeral in Springville, and it was the day after they had the memorial, he did mention to us that he couldn't stay there any longer. I thought that was a little odd, and that he had a friend in Rexburg on Pioneer Road that had an apartment that he was going to move into, and that this friend was not there very much. And so it would work out pretty good for him.
Do you recall if he indicated who the friend was?
He never did say a name.
And you attended Tammy's funeral in Springville, Utah?
Yes.
Did you make any observations of Chad at the funeral?
He actually seemed pretty up-minded. We was around the casket and looked at and seen Tammy in the casket and that, and around the family, and he didn't seem real sad. I thought, for some, your wife had just passed away 3 days earlier, and he seemed like he could handle everything okay. And then in the funeral, when he spoke, which personally I thought was odd too, because mostly people don't do that when their wife dies or spouse dies. And he did show some emotions, and he spoke for quite some time, I remember. And so, yeah, he did. I would say for your wife just dying, he did a pretty good job. So.
And when you say for his wife just dying, he did a pretty good job, would you have expected him to be more emotional?
Yes, I would.
At Sometime after that, after you'd returned from Springville, did you end up reaching out to Chad?
Yes, I believe it was about 2 or 3 days after the memorial they had. Alice and myself thought, well, maybe we ought to call Chad and go see him, see how he's doing, see how he's getting along in that apartment all alone. And we thought we'd take him pizza. So we gave him a call, and he says, oh, no, I'll just come over and see you within an hour or so.
And he did not invite you to the residence that he was staying
No,
at?
he did not.
Did he, in fact, end up coming to your residence?
Yes, he came to our house about 6:30, I believe. Alice had just made some cookies, and so he was sitting there eating the cookies at the table.
And when he was there, do you recall him telling you anything?
Yes, he mentioned, we asked him how he was getting along. He said he was doing pretty good, and that he had a girlfriend, he told us, and he seemed like he was hesitant to tell us who it was. But then he mentioned that her name was Lori Vallow, and I thought to myself, well, I've heard her name before because I heard her on podcast speaking with Melanie Gibb and Jason Mao a couple of times. So I was familiar with her already. So.
And you indicated that this visit would have taken place 2 to 3 days after the memorial.
Yeah.
And the memorial was the day after her funeral.
Right.
And the funeral was 3 days after her death.
Yes.
So this is a week or a little bit more than a week after Tammy
Yeah,
had
I
died.
believe it was probably the following Saturday or Monday.
And so about a week later, a little over a week, Chad was telling you that he had a girlfriend.
Yes.
Did he say anything about his girlfriend?
He said that she was beautiful and that they were going, that she was going to be his second half of his life, I guess, wife, you might say, and for his mission that was left on the earth.
And was Lori with him on that occasion?
No.
Did you end up meeting Lori?
Yes, Chad mentioned that Lori and a couple of friends that was with her was here in the area, and if we would like to meet her. And so we worked in the temple as officiators of Rexburg Temple, and he said that they would be in the temple that Tuesday afternoon doing some work, all four of them. And so would we like to meet her?
And did you in fact end up meeting her on that occasion?
Yes, about 5:30 when we were waiting in prayer meeting. Chad come up and tapped me on the shoulder, and we went out in the hallway, and there was Chad and Lori and Melanie Bedreau and another lady that I'm not sure who it was.
And did you speak with them for very long that day?
Probably no more than 5 minutes or so. We didn't have much time because our meeting was about ready to start.
Ms. Blake, sorry to interrupt. Can you wait just a second? We had a little technical issue we're going to sort out for a moment. It has been. I'm not sure. Yeah, I think it's. Okay, thank you. All right, apologies for the interruption. You can continue, Ms. Blake.
I'll turn my mic on. On a later date or on another occasion, did Chad and Lori come to your residence?
Yes, I probably about 2 or 3 nights later, I can't remember, something like that. They both came to our home.
And did you have a conversation with them?
Yes, we spoke about how they were getting along and how things were going for them, and that seemed to be going good at that point.
Did you make any observations of their interactions with each other?
Yes, probably the biggest thing I noticed was that they were, to me, it seemed like they were acting like a couple of teenagers that were first in love. and they were holding hands and sitting real close to each other, and Chad was rubbing her leg, and I just thought that was odd for your spouse just passed within a week and a half.
Had you ever seen Chad act like that with Tammy?
No.
Do you recall talking to them about their plans for a future together?
Yes, they mentioned that they would be returning to Hawaii to probably live permanently, and that Lori had lived there already in the past, off and on, and that he had a friend that wanted him to help write a book, and so that he was going to go over there and help write the book.
Did he indicate if Lori was going to go with him?
Yes, I think, yeah, yes.
Did they talk about wanting to get married in the future?
Yes, they were talking about that they would get married. The words that I remember is that when Christ told them that they would get married, that they would.
And do you recall if there was any conversation regarding what had happened to Lori's spouse?
Yeah, Alice was asking her, so you've been married before? And she did mention that she had had a husband and that he had died in December of 2018 of a heart attack of their marriage.
And she indicated that he died in December?
Yes.
Do you recall any conversations or statements made regarding Lori's daughter?
Yes, we asked her if she had had any children, and she said that she'd had many, and that Chad spoke up and says that she had a daughter that just passed on. And so we didn't really ever get a straight answer of how many children she did have.
Did Lori correct him or say anything different when Chad mentioned she'd had a daughter that had passed on?
Not that I can recall.
And Lori never mentioned having a daughter living.
Not that I can recall.
Did either of them ever mention Lori having a minor son?
No.
Do you recall them coming to your residence on another occasion, a later occasion?
Yes, they made another visit before they left to go to Hawaii, and before they went to around Thanksgiving time, they were going to take Chad's family to Disneyland in California. And at that time, they mentioned to us that they'd got married, and that they showed us all of their wedding pictures.
Did you know they were going to get married?
Just from what they'd said earlier, that they would, one of them, one day. And of course, I understand they got married November 5th, and Alice talked to Emma on November 6th, and Emma told her that
I'll
she
object, Your Honor,
was
to
married.
hearsay.
That's a hearsay statement, so that any answer there will be stricken, not to be considered by the jurors, please. And Ms. Blake, you can ask another question.
Thank you. So Chad and Lori showed you their wedding photos when they visited you?
Yes.
And when did you say that visit took place again?
It was before they went to California on Thanksgiving time.
And that was in 2019?
Yes, 2019.
And you said they were taking Chad's family to Disneyland?
Yes, his married kids and the ones that weren't married, all of them that was there.
Did they ever mention taking Lori's kids with them?
No.
Did you ever see Chad and Lori with any children belonging to Lori Vallow?
No.
Did Chad ever tell you how his kids felt about his being with Lori?
I'll object, Your Honor. That question calls for hearsay from Chad's kids.
I ask if Chad told him, if Chad ever said how his kids felt.
Yes, the objection's overruled.
He mentioned several times that they were feeling good about it, that they were missing Tammy, their mom, but they felt good about Lori and moving on with her. He told us that several times.
Did Chad ever say anything about how Tammy felt or would feel about his relationship with Lori?
He did mention to me 2 or 3 times that she visited him in spirit and was fine with everything, and was that her mission was complete on this earth and that she was to move on, and that yes, that and comfort her kids that they were fine, or that she thought it was fine.
And after that visit around Thanksgiving in November, did Chad ever return to your residence at a later time?
I can't recall for sure. They might have come before. They did. I know 2 or 3 times before they went to Hawaii permanently.
And when you say before they went, was that Chad and Lori?
Yes, Chad and Lori both.
So they visited your residence on a few more occasions?
Yeah, probably no more than 3 all total.
And then you indicated that was before they went to Hawaii.
Yes.
Or I think you said Hawaii permanently.
Yeah.
At some point after they'd gone to Hawaii, did Chad end up returning to your residence?
He did after Lori had been arrested and was brought back to Rexburg. He got back. He came to our residence a day or 2 after that.
And without going into the details of why he was there, do you recall a conversation taking place regarding his prior statement about Lori having a daughter that had recently passed away?
Alice had asked him more about the kids, and I remember him commenting. She asked if Kylie, would be in college or whatever, or where she was at, and he said that she didn't really like him too much, and that she just kind of stayed away. That's about all that I remember of that.
Just 1 moment, Your Honor.
Yes.
I have no further questions, Your Honor.
All right. Thank you, Ms. Blake. On cross, would you prefer to do that before or after lunch?
We can do it after lunch.
Okay. We'll go ahead and take the lunch recess at this time since it's a logical breaking point. We will go back on the record at approximately 12:45, and we can continue with cross-examination at that time.
All rise, please.
All right, I think the jurors are already starting to get lined up, it looked like, to be brought in, so we'll just remain standing. Apologies for the longer lunch break. We had a technical issue to sort out, but we're ready to bring the jurors in.
All rise, please.
We're on to cross-examination at this time. So I'll remind the witness you're still under oath for your testimony. And then is it Mr. Archibald that will conduct cross? All right, Mr. Archibald, you can cross-examine if you'd like.
Mr. Gilbert, you knew Chad and Tammy as their neighbor,
Yes.
and then you also attended church with them.
Yes.
And which church was that?
The Salem church there in the Salem area, Salem 3rd Ward.
Okay. And by ward, you mean which church?
It'd be the one that's just north of Rexburg, going down the Salem Highway. There's 3 wards that meet there, and it's a Church of Jesus Christ of Latter-day Saints.
Okay. And you've known Chad and Tammy Daybell since about March of 2017?
Right. Yes.
And you knew their children as well?
Yes.
And did you know Chad Daybell's name before he moved in?
Yes, I was familiar with his books, and I knew he was an author.
And what kind of books were they?
They were written as last day vision, things that were kind of like going to happen in the world in this area.
And did you like those kind of books?
Yeah, they were kind of interesting. Yeah.
Okay. And so you would buy his books, and they were supposed to be fiction.
Yeah, he said that they were based on fiction with mixed of some of the visions that he'd seen.
And so when he talked to you about this, he would say, my dreams and my visions are real, but then I put fictional characters with them and write a book about it?
Yes, pretty well. That's the way he would word it.
Okay. So did you think that he was making up his dreams and his visions? Was that the fiction part, or was the fiction part the names associated with his dreams and visions?
Mostly the names were all fictional in them. The situations were I took it as visions that he'd had, not mainly word for word, but, he would use that for the basis.
Okay. And would he talk to you privately about his dreams and visions?
Sometimes at church we would talk between meetings or something.
And did you believe that he was telling you the truth, or did you feel like he was full of crap?
I felt like that I didn't know for sure, or it hadn't happened to me like that. I thought, well, I guess it could have happened to him, but I wasn't 100% sure, put it that way.
Okay. And now, eventually, after getting to know you, he wrote a series with you in books. Is that right?
Yeah, that's correct.
And those books were called the Times of Turmoil series?
Yes.
And he wrote about a brother Gilbert. Would that be you?
Yes, that's what he said.
All right. And where does the brother come from?
In the LDS church, a lot of times people are called brothers and sisters, just addressed that way.
Okay. So you weren't really his biological brother.
No.
But in church lingo, he would call you Brother Gilbert.
Yes.
And these books, Times of Turmoil, what are they about with you in them?
They were about, he wrote 2 different series, and this was the second series, which was kind of updated, I guess, for the times that we were in. And they was pretty well the same type of series, just last days visions, things that's going to possibly happen. That's what he said.
And so when you read these books with your name in it as Brother Gilbert, was that flattery or was that an insult?
I would imagine I think it was flattery. He told me beforehand that he was going to have me in one of the books, so I knew it was coming.
Okay.
I think it was flattery.
All right. And he wrote good things about you in there.
Yes.
All right. He didn't insult you in any way.
Nope.
Okay, good. So with these books, did you then take that as this is not fiction, this is real life for Chad?
No, I feel that he thought a lot of that stuff was going to happen that way, and that's why he wrote it that way. So I would think he thought it was going to be real life for him.
And it was these times of turmoil was about the end of the days, end of the world.
Yeah. Yes.
And that bad things were going to happen, and then Jesus would come.
Yeah, thereabouts. A lot of minor stuff would happen before that Christ would come back.
Okay. And so you talked to Chad Daybell about these books. Were they successful?
I believe he sold them pretty good from what I know. Yes.
Who was his, if you know, who was his target audience in these books?
Mainly people that were in the preparation, I guess, for the things that's happening.
Getting ready for the end of the world?
I don't know if I'd say the end of the world, but preparation, being prepared.
So when you talk about being prepared, I mean, the general theme is when Jesus comes, that's going to be great. It's going to be good, right?
Yes.
So being prepared, are you talking about being prepared for bad things that come before the good things come?
Being prepared to be able to survive the bad things as they go along. If you're prepared, you'll be able to handle them a lot better than if you're not.
Okay.
But that took into account a lot of stuff like physical items and everything too.
Okay. So when we talk about seminars with preparing a people, when we talk about being prepared for Jesus coming, you're mostly talking about bad things that are going to happen before Jesus comes.
Some of the speakers spoke that, some of them didn't. Some of them was on food preparation and items such as that. They didn't really get into real wild last days, things like that.
Okay. But isn't the theme of when Jesus comes again, it's going to be a good thing, not a bad thing?
Correct.
Okay. Now, you said you also listened to podcasts about this. Can you tell us about some of those podcasts?
There's been several different podcasts in the past. I know that Lori was involved with the podcast with Melanie Gibb and Jason Mao that we started listening to off and on, and they interviewed Chad one time. And
now, our podcasts, are they like on the radio or on the internet or on YouTube?
You could get them on the internet.
On the internet.
On a website.
So you would have to go looking for podcasts about certain topics?
Yeah, yes.
And you and your wife would do this together?
Objection, Your Honor. I think I've waited a while, but I think this is beyond the, well, actually, I don't see the relevance of where we're headed here.
Relevance, Mr. Archibald.
Your Honor, he testified in direct. I'm following up on questions from the state of Idaho. I'm just going through what the state of Idaho elicited from this gentleman.
And Your Honor, if I may briefly respond.
Go ahead.
I think in response to a question, he indicated something about listening to one podcast. There was not further discussion on that. There wasn't discussion of multiple podcasts, how he got them, or anything along those lines.
All right, I'll allow a little bit of latitude here for you to keep going, Mr. Archibald. At some point, it needs to tie into relevance here. I'm concerned we're getting outside of relevant testimony.
So you mentioned a podcast about Jason Mao. Who is that?
He's a man in Arizona that was involved with the podcast. I don't know a real lot about him.
Is he the retired policeman who now is a motivational speaker?
Yes.
Objection, Your Honor, relevance.
I think we're outside the scope at this point, Mr. Archibald.
You mentioned Melanie Gibb.
Yes.
The jury's heard from Melanie Gibb. Would that be Lori's friend?
Yes.
And do you remember anyone else on that podcast other than Lori Vallow?
No, just those three, and they would interview people sometimes. They interviewed Chad one time, and we heard that.
Does the name Thor sound familiar?
Yes,
Okay, so was it the same podcast involving Thor?
yes, I believe. Yes, it was.
Your Honor, I have what's marked here as Defendant's Exhibit E. It's a podcast recording with Jason Mao, Thor, Melanie Gibb, and Lori Vallow. I'd ask to introduce this exhibit to play to the jury.
And Your Honor, may we approach?
Yes.
I'm good right now. Okay. Yeah, there's one. All right, thanks.
Okay, we're back on the record. Ladies and gentlemen of the jury, it doesn't happen often, but sometimes it does happen where we need to hear a motion that would allow some argument that would be improper for you to hear at this point because it relates to evidence that may or may not be admitted. So for that reason, we are going to need to hear this motion at this point. I'll have you return to the jury deliberation room to wait while the motion is argued and heard. So not considering this a scheduled break, it's just a motion to take up to keep the evidence moving and have me make a ruling outside of your presence. So at this point, I'll have everyone rise for the jury and they'll retire to the room.
All right, please.
Yes.
All right. As a practical concern, if it's admissible, we can do that. I have not reviewed and don't know what the podcast has. So in order to, I think, lay an adequate foundation for me to consider that, I need a proffer from the defense about what is contained in this podcast recording that you believe would make this admissible evidence at trial.
And Your Honor, I apologize for interjecting, but before the defense does that, I would ask that the witness be excused then. My concern is the proffer from the defense may educate the witness who they're attempting to lay foundation through.
I think that's a good point, Ms. Blake. I think it would be appropriate then that Mr. Gilbert will have you wait outside while we take up this procedural issue, and then we'll have you return to the stand once it's been determined by the court. All right, Mr. Archibald, if you'd make a prof regarding the content.
It's dated November 4th of 2018. It's a recording. Melanie Gibb is the first speaker. She, from 0 minutes to 4 minutes, she introduces everyone and welcomes people to the podcast. There are people in attendance. She speaks for 4 minutes. Then a person by the name of Thor Furuseth identifies himself as a Native American Indian. He talks about his hard life and then finding God, finding Jesus. He speaks for the next 14 minutes. Then Jason Mao speaks for the next 13 minutes. He introduces himself as a retired policeman and now a motivational speaker. He talks about being down in the dumps, so to speak, and then finding Jesus, and is now a motivational speaker. Lori Vallow is the next speaker. She speaks for 9 minutes. She introduces herself and talks about her former husband, Joe Ryan, abusing her children, and how finding Jesus and attending the temple helped her escape that scenario. It then goes back to Jason Mao, Melanie Gibb, Jason Mao, Thor, Lori, Zulema. So even Zulema is there, and she talks and asks questions. So it's a podcast that I believe this witness listened to, since he identified the names. He identified Lori Vallow, Melanie Gibb, Thor, and Jason Mao. They talk about their motivations. They talk about their beliefs. I think it would educate the jury in what the subjects of these podcasts are. It would educate the jury, fill in some of the blanks they may have about these religious gatherings, these religious meetings. And so that is my purpose in admitting the exhibit.
And can you give me a little more information on how this would relate to proper cross-examination with this particular witness that's on the stand, Mr. Gilbert?
Mr. Gilbert testified through questions from the state that Chad Daybell had told him about dreams and visions, and that his visions were real, his books were fictional. He was teaching gospel topics, religious subjects, that he would listen to Chad, that he was a friend of Chad, and that they would talk about religious issues. Chad introduced Lori to the Gilbert family, and they had discussions with them. So it provides some background, some foundation into what the state has introduced in their case in chief.
All right, and as a final question, Mr. Archibald, then would it be necessary to publish the entire podcast? Is that what you want to do, all the witnesses on the stand? Is this something you have excerpts that you think are more relevant than other places that could be played, allowing the jurors to further consider that in deliberations?
The first 40 minutes, it is an hour and 49 minutes long. The first 40 minutes are distinct in that all four of the speakers identify themselves and their history. And then it repeats itself. Then with questions and more comments, then they all take turns responding to questions. So I would be okay, actually, Your Honor, with the first 40 minutes played rather than the whole hour and 49 minutes.
Okay, thanks for your responses, Mr. Archibald. At this point, then I'll hear argument and objection from the state.
Thank you, Your Honor. And the state objects for multiple reasons. One, this particular exhibit was not listed on the exhibit list provided to the state. I do recognize that this was provided in discovery. I believe it was recovered from electronic device. However, based on what's been presented today, there is a lack of foundation. The witness simply testified about a podcast that he'd heard, identified some individuals he recalled being present. There's no indication that he was present to authenticate that the recording was true and accurate of what took place. He has not indicated the date or time that this podcast was made. He has not indicated a date or time of when he located or heard it. He has also not indicated the location where he found it or through what media he was able to hear it. In addition, it contains hearsay. There are 4 speakers identified. None of them are here today as witnesses, including Mr. Gilbert. The other witnesses' statements would be hearsay. In addition, it's been presented that there are statements of the defendant in there. It appears to be an attempt by the defendant to get statements in without taking the stand. Further, the purported reasons for the relevance include Mr. Gilbert talking about beliefs Chad Daybell shared with him. There is no indication or representation that Chad Daybell is on that podcast presenting any of his beliefs. It does not appear to be proper cross at all. Instead, if there is any relevance to obtaining the religious beliefs of these other individuals, I think they could be subpoenaed in by the defense or should have been. Further, there is simply no relevance of this. Mr. Gilbert just testifying that Chad's shared some religious beliefs does not appear to open the door to then 4 other individuals talking about and or sharing their religious beliefs in a podcast. So for all those reasons, the state would be objecting to the introduction of this exhibit. And we would request, if the court was going to consider introducing this exhibit, that we take a recess for the state to review it. I recognize it's in the discovery, but given the fact that the discovery production in this case particularly has been very voluminous, and this was not highlighted as an exhibit until recently, we would just request time to be able to review it if the court were going to admit it.
Okay. Let me address a couple of those objections made by the state. First, I wanted to clarify. So the defense, I believe, indicated that as part of your exhibit list would be all of the state's exhibits. Is that correct, Mr. Archibald?
Yes.
And is this an exhibit that the state had at some point put on a exhibit list?
Are you asking me?
Either one of you. Is this on the state's exhibit list?
No, Your Honor.
All right. So, Mr. Archibald, was this disclosed as an exhibit or not? I thought I heard a representation that you thought it had been.
It was disclosed in discovery, but I don't think we put this on our exhibit list because we did not know that Mr. Gilbert was going to say what he said.
All right, I've considered the objections here. Here's how I'm going to rule on this exhibit. First, it was disclosed in discovery. It wasn't listed on the exhibit list. However, it was initially testified to by the witness, Mr. Gilbert. The court has to consider primarily Idaho Rule of Evidence 403, which is whether or not this would be more probative than prejudicial, or whether it could result in undue delay, wasting time, or presenting cumulative evidence, among other things in that rule. The court's considered that time of disclosure where it was revealed in discovery but not put forth as a specific exhibit. I will note that in weighing things out, the defense has offered very few exhibits up to this point. Of course, they're not in a case in chief yet, so that's to be expected. The witness himself may or may not be able to lay foundation for this. So if Mr. Gilbert recognizes this as the podcast or a podcast that he's previously listened to and can confirm that this seems to accurately represent that podcast that he previously has heard, then I think that would allow enough of a foundation for the court to consider the admissibility on that based on a foundation, but that's got to come next with the witness potentially laying the foundation. I'll overrule the objection that these may be comments of the defendant that somehow work against the Fifth Amendment right. There's been plenty of other statements introduced she's made during the course of trial where she still maintains her Fifth Amendment right. Statements made to other, and these are statements outside of the scope of that Fifth Amendment right in this prior broadcast. The proposal here is that this be edited down essentially to what's being heard as the first 40 minutes. In order to keep things moving at this point, what I am going to do is allow the initial publishing of it, the start of it, for the witness to see if a foundation can be laid for its admissibility. If we get to that point of admissibility and the foundation is laid, then because it's been disclosed in discovery, despite the objection procedurally, I'll allow the first 40 minutes to be published to the jury. However, I do want to be able to stop the recording at any given point over a more specific objection from the state to determine whether or not it'd be necessary to have a further in-camera review of the exhibit or review of the exhibit by the state, at least outside the presence of the jurors. So we need to be ready to stop it at any given point, either on me indicating that needs to happen or an objection made by counsel. So I'll provisionally allow for it to go forward to see if it can be admitted with foundation. The first 40 minutes may be published on that conditions I've indicated. So with that in mind, that'll be my ruling on this exhibit. I do find I'll also indicate under 403 that the relevancy here does come in the fact that the state has specifically included as overt acts in the conspiracies, the religious beliefs of the defendant here and the co-defendant. And because of the overt acts expressly stating religious beliefs to be part of that, I would find that the religious beliefs have been brought into the case and are relevant for the jurors to potentially consider. So that's the court's ruling. We'll have the witness return to the stand.
And
you can
Your
start
Honor,
the initial broadcast, Mr. Archibald, and see if a foundation can be laid. Ms. Blake.
and Your Honor, I apologize, but I just wanted to make the record clear. The objection to the defendant's statement is not anything to do with the Fifth Amendment. It's based on the fact that statements of a party opponent are allowed. I do not believe that, and I believe the defendant is actually barred from introducing her own statements through recording. So if the court is going to allow it, we would ask the court to reconsider that part. I believe that she would be barred from introducing her own statements.
That may be the case, Ms. Blake, but I just don't know what the statements are. I think it somewhat depends on what those statements are, and I haven't heard this. So at that point, if there's a renewed objection when it gets to where she's going to make commentary, we may well have to stop, and I may have to review the recording. So to keep things moving, we'll start at that point. I'll keep that objection under advisement and further rule on that if it's brought up by the state. So that'll be my ruling on the objection to admission of the defense exhibit. We'll have the witness return to the stand, please, and then we'll have the jurors brought back in.
Okay, so we can play that a little bit later on because we're getting close to where the lunch should be coming to a close here, and they're going to come back up in court. Thank you, Bama, for the reminder. Yeah, you guys, if you don't mind giving me thumbs up, I would appreciate that so much. They put out a thing that they said that the Pope's official cause of death was a stroke. They said that 3 hours ago, but I had not seen that. Looking for, hang on. Everything, like if you try to find like what's going on, like true crime news, I'm trying to find some true crime news here. And everything is just, so what's up with this guy that were these kids throwing rocks off of the, I'm gonna share this tab. No, I'm not. There's a thing on Court TV where this kid, Joseph Koenig, threw a rock and it unalived Alexa Bartel. And I guess that's been going on in court lately. And I think it's one of those things where they were standing on an overpass, a bunch of kids being stupid, and they dropped the rocks below. I've heard of that a lot, and how people have gotten really badly injured over stuff like that. I know while I was listening to that audio, I was doing some organizing too, Bama. Closing arguments should be occurring any moment now. Ow. My kitty's she's trying to climb up on the back of the chair. What was the other thing I was going to tell you guys about? There's so many things that I want to share with you guys that I can't, because it's like something I find on another channel. I'm like, I can't share that with you because it doesn't, I don't want to get copyrighted. Like, oh, look at this. Oh, I wanted to ask you guys. So they came out with the JFK files, right? The biggest unsolved crime of the century, supposedly, or of our lifetime, and nothing has really been said about it since they came out. So I just kind of wondered if they're finding anything at all. I mean, in all these years, we've been waiting for all these files to come out on what happened with his assassination. And now that they've got all this information in front of them, are they still just going through it all? Are we waiting on a big documentary to happen? I can't believe nobody's spoken out. I think that, like, I literally looked it up one day. You could go online and look it up and see everything. It's a lot of just very hard to follow stuff. So I'm assuming it's taking some time to go through, but there's got to be guys that are familiar with this that have already found some stuff. Why haven't they come out with it? Or are they just not finding anything? Yeah, Nicole, that's what I heard this morning too, that he had pneumonia or something and he had been hospitalized and all that. But then they just announced 3 hours ago that the Vatican said it was officially a stroke. I'm talking about the Pope. Right? No news on the JFK files since the week that it came out. There's been nothing. They're still digitally, I can't say that word, Matt, digitizing documents. Can you imagine? Oh, and then there's a animal abuse case going on right now in Phoenix. Y'all, it was a Chihuahua that's unalived, and I won't even look at it. I won't even. I won't even open the video. I can't. The other thing I was going to tell you guys about, did you watch, my notes out. What was her name? I've got it right here. Oh, that's Clinty. Hang on. The Death of Mary Yoder. Did you guys watch that documentary? Was it on Netflix or was it on Hulu? Oh, what was the name of it? Hang on, I'll tell you right now. I got it right here. This is something I'm going to do something on here. I've got to do that, and I've got to do Pam Hupp. So, Little Miss something. It was Little Miss something, wasn't it? Or I can't remember the name of the show. So, Dr. Mary Yoder was a married woman, had a son and a daughter, I think. Yeah, a daughter. And it was out of New York. And a girl, Caitlin Conley, was accused of unaliving her ex-boyfriend's mother. She was sentenced to 23 years in prison, but she recently got out early. They overthrew her conviction based on some, just small errors, just something really crazy. Okay, it was, I think she had two girls and a boy, the mother. This happened in July of 2015. And I watched the whole documentary, and it was really interesting. And there was just something about this girl as she's talking that really caught me and made me think, I don't know what to believe in her. Like, she doesn't seem sincere. She doesn't seem believable. And so what I did was I took notes, and I've been researching little things here and there on it since then. And I've got it put to the side because I'm like, I'm going to do something on this. I want to do a documentary on it. And then if the trial comes up, I guarantee you it'll be, unless the state doesn't allow it, I guarantee you that it's going to be streamed. Because there was a lot of question as to whether or not it was the son that actually did it. And if he did he set her up? But I don't know. It was a really interesting case. She worked because she was dating the boyfriend, she got a part-time job, or did she? I don't know if he got a job, but she worked at the doctor's office. And there was even some suspicion on the dad at one point. I mean, it was just one of those whodunit things that I don't know if they really found out who done it. Was it yesterday that he met with Vance? I thought that footage was from long ago. Barbara, you're going to put yourself in timeout when Lori gives her closing arguments? Oh, here, let me change this so you guys can at least see what's going on, huh? I'm so sorry. I do apologize. I've got you blocked. So, that's not what I wanted. What did we say? Two? No, I got the wrong time up there for the lunch. They should be coming back, though, because they said it was going to be a short lunch. It's been an hour, has it not? There's a restock of Star Crunches. Yes. Yeah, and I've heard a lot about when those kids, kids used to do it all the time. They're going to stand up on top of a thing and they drop stuff on the cars. But the winch, like I remember there was one in Florida where a mother was unalived. I don't think this is the same case. I think this happened years ago. But it's on court TV. Arizona's on. Yeah, I know. Pacific. It's 2 p.m. No, it's 1 p.m. there. 1:10 p.m. now. They should be back from lunch or coming back from lunch. Oh, but you know what? They got a 30-minute delay that they're not going to show. Crap. Are they going to be gone for... I guess I could go back to the video. I thought they only said an hour. How long has it been, Bama? I'm ready for opening statements. Mark's having a cocktail already. Has it been an hour, Ann? We were already on a 30-minute delay. So when he said it's been he said we'll be back in about an hour, we should be an hour and 30 minutes behind them. Oh, I know. Hey, let's go in here to I'm going to go in here to Nate's updates real quick. I'm going to keep that court stream up and I'm going to read y'all what Nate's writing down. All right. Back in the courtroom. He said that Lori's at the defense table chatting with her investigator and drinking a bottle of water. Trina Kay, the prosecutor, her paralegal, and Detective Nathan Duncan are at the prosecutor table. Colby, Ryan, and his wife, Kelsey, are at the courtroom sitting next to Kay Woodcock. I'm sorry. So that's just that's the last one. That's the latest from Nate, and that came. Oh wow, that was 30 minutes ago. What happened, Nate? What else is going on, Nate? Can he tweet when he's in there? Did you guys know that East Idaho News is an independent, like it's owned by, well, it says that they're a small team of local journalists that run it. They're not a big business or corporation. Our stories are produced to inform and serve the public. We don't have a paywall or require a subscription to use eastidahonews.com, but there is a cost associated with bringing your stories in every day. So if you do like $1, you're able to contribute $1 more a month or annually. We sincerely appreciate it. But I mean, he has worked so hard on this case, you guys. I wanted to show more of his stuff, but that's the only reason I haven't, is because I'd rather say go over and watch his channel because, you know, he deserves you got people to go over and get the views. I'm sure you think Daryl Brooks is jealous. Okay, we've got a feed in the courtroom. We have audio. You're not late, Sherry. You're just on time. We might still have a 30-minute delay, but that doesn't make any sense because it's been an hour since he said we're going to lunch. Was it not? And what we were watching was on a 30-minute delay. Right. Hi, Cher. How are you doing? Oh, it is going to be a three-ring circus for her appeal. And I bet those appellant attorneys, I wonder if a bunch of them are jumping on there to get involved. Because can you imagine the exposure you get from working on a case like that? This case is as big as OJ. That's how much media it's gotten. We're waiting on another late juror. That could be it. Very well could be. But Law and Crime usually doesn't pull it up unless they're ready to go. So it shouldn't be long. Brandon's trial chair starts on the 30th of May. They're going to have a hearing on the 14th, and we'll be here for that. Ann says, I think it'll become old news if something better comes along. It probably, to some people, already has become old news. I don't know. A lot of people are just really, they got their hearts in this one because of those two babies that got hurt. All right, we have
That's fine. All right, we'll go on the record. State of Arizona versus Lori Daybell, CR 2021-001704. Before our break this morning, the defendant moved to have an exhibit admitted for appeal purposes only. That exhibit number, the correct number, I believe, is 269.
That's what I understand, Your Honor.
All right, so it's ordered that 269 would be admitted for appeal purposes. It won't go back to the jury during their deliberations. Go ahead and get the jury lined up, I guess.
I was looking up how many years she's facing for conspiracy. It doesn't say. Obviously, we know she's already serving a 3-year life sentence, or 3 life sentences.
All right, the jury's now present. Please be seated. This is time set for closing arguments. The state can proceed with its closing argument.
Here we go.
July 18th of 2019, just 7 days after this defendant and her co-conspirator, Alex Cox, shot and killed Charles. This defendant texted her soon-to-be next husband, Chad Daybell, about Charles's life insurance policy. Her words tell us that she was involved in this killing. Her actions and her words of texting Chad Daybell tell us the motives behind this murder: Chad and money. The morning of that 18th of July, Lori Vallow texted Chad and said, quote, "I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart." Who do you think he changed it to? Later that day, after she spoke with the life insurance company, she sent Chad another text. Quote, "So I talked to the insurance company. He changed it in March. Probably it was Ned before we got rid of him." Lori Vallow's words 7 days after Charles was shot and killed tells us that we was her and Alex killing Charles. Why? For that money. But Lori Vallow's plan to kill Charles wasn't just known by her lover, Chad Daybell, and her accomplice and co-conspirator, Alex Cox. It was also known by her brother, Adam. Adam told us that he knew about Lori's beliefs. He knew what she had been saying about Charles's concerns for himself. And he told us that he knew about this plan for an intervention to talk to a stakeholder. That morning of July 11th, when Charles arrived at Lori's house, as she knew he would, he texted Adam and said, "Al is here." Adam texted back, "They are planning something." He knew. And 3 days later on Saturday, when Adam finally learned, when his friend Googled Charles, that he had been shot and killed by Alex, Adam told us he went back and talked to his mother and he confronted her about this. And he told his mother, Lori and Alex conspired to kill Charles. He knew, and he was right. Lori's ex-friend, Christina Atwood, she told you about that very uncomfortable dinner on June 9th, a month before the murder, where Alex Cox was talking about just wanting to kill Charles. He said this multiple times, and this defendant didn't care. In fact, she talked about how she had been drugging Charles. Christina told you she was so disturbed by this, she actually went and saw Lori the next day, June 10th, and told her, "If something happens to Charles, I'm going to have to go to the police." Christina knew. She was right. And Nancy Jo Hancock, now she had just met Charles a few days before, and they had talked and texted and had been on the phone for hours, you heard. Charles had told her all about Lori, the things she was saying, the things she was doing. She told you that she knew that Charles was concerned for his own safety. And she understood the motive. She told Charles the night before, "You probably should just tell Lori that you've changed the beneficiary, that she's no longer going to get that money." Nancy Jo knew, and she was right. Lori Vallow wanted the $1 million, and she wanted Chad Daybell. And she and Alex used that twisted religious beliefs they had so that they could kill the evil, possessed Charles and be like Nephi. The evidence that has been presented in this trial will prove to you beyond a reasonable doubt that this defendant is guilty of conspiracy to commit first-degree murder. So I want to split up my closing into 3 sections. First, I'm going to talk to you about the timeline and the motives in this case and the evidence that supports those. Second, I want to talk to you about the jury instructions and the evidence that's been presented to you in court. I'll remind you that anything the defendant said in her opening was not presented at trial through a witness or through an exhibit, and it is not evidence. using the evidence that has been presented and admitted at trial, the state will show you how, again, the defendant is guilty beyond a reasonable doubt of this crime. And finally, I'm going to talk to you about those justification defenses, the excuses and the reasons why the defendant would like you to believe that they had a valid basis for shooting and killing Charles on July 11th. And we'll talk about how, in fact, there is no justification for what they happened. What happened that morning was a first-degree premeditated execution of Charles Vallow. So let's go through the evidence. The timeline really starts, and we know it goes back much further than this, but the big change occurs on June 29th or 30th, when you learned that Charles Vallow learned about these KK Walker emails. He learned about that affair with Chad. Now he knows Lori is cheating on him. We know that he contacted Chad Daybell about it. He contacted Chad's wife about this. He told Adam about it, and he told the defendant about it. So everyone knew that Charles now knew this. July 9th is now the first time that Charles is going to be coming back to Arizona. We know from the time he learned about that affair, he hadn't been back until this planned visit to see his son, JJ. We know at 1:13 p.m., Charles texts Adam and books him a flight for the next day. At 1:21, we know that Adam is contacting Alex. And they talk for 20 minutes. And Alex lets Adam know, sure, you can stay with me. Of course, Alex doesn't know the plan yet, the mission. Lori then starts talking to Chad Daybell. We know that she knows about this intervention. She knows about Adam coming. And we know this because, again, of her text messages. We see Lori then starting to round up the troops. Why does she do this? Because she wants to ensure that on July 11th, it is Charles and only Charles coming to the house and not the intervention of Adam or Brandon or Zach coming over to help him. So she has Melanie. Tells her she can't go to this wedding. She has to stay here. It's coming to a head. This week will change everything. Call me. Then we have July 9th, the text messages with Alex. She tells him, so the plot thickens, call me when you can. He doesn't call her initially. So she sends him another message, this one really letting him know. She specifically tells him, I'm going to need you to stay close to me the next couple days. Mel too, she can't go to Utah. She's got a job. They are planning some kind of intervention, but want Mel out of the way, so I'm left alone. She talks, I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. And then what happens? This gets Alex to call, and they talk for almost an hour. An hour planning how they're going to stop the intervention, how they're going to be like Nephi. As we get to the 10th of July, and we continue through this timeline, we see Lori again talking religiously with Chad. 149 minutes that morning. She's also texting Lori, or texting Melanie Boudreau, Melanie B, telling her that it's important for the mission, for Melanie to help her by keeping Brandon distracted. And we saw those messages where Melanie says she'll pretend to be sick. We know that on the 10th, Adam arrives in Phoenix. And now we have Summer helping the defendant, letting her know what is going on with Adam and Zach. Everyone is covered to ensure that Charles will be alone on the 11th. We have the continuing talks with Chad, her soon-to-be husband. As we get into the 10th in the afternoon, we know that per their agreement, Adam calls his brother Alex. Hey, I'm here. Brother doesn't answer. Sends him a text. I'm here. No response. Why? Because the night before, his sister Lori told him, we have a mission. We must be like Nephi. Charles is coming into town. You must stay at my house the night of the 10th so you can be here the morning of the 11th. We also know that Summer gave Lori an out. Hey, you can stay at my house. No one will know where you are. We're going to be out of town. You can hang out here. Lori doesn't take her up on that. She has a mission to do. As the night grows on the 10th, Adam continues to try to reach his brother Alex. Again, no response. And by 45 or so minutes after that last text by Adam, we know Alex is already at Lori's house. He's there with his gun and a garbage bag of some underwear. Why? That gun is important. A loaded weapon, 2 extra magazines of ammunition with him. He is ready for his mission. And again, Summer is updating her, telling Lori that Zach and Adam are still at her house. They're going to go stay at Mimi's. And she even tells him that Adam is still waiting for Alex to get back to him. Still, he doesn't understand. Why isn't my brother responding to me? I was supposed to stay there. And again, what does Adam bring over? Gun and a garbage bag of clothes. That's all he needs to be part of the mission. When we get to July 11th, we still have Lori talking with Chad. We see those text messages going back between them. And then we start learning from the GPS from Charles Vallow's phone as he arrives. 7:35 a.m., he arrives at 5531 South Four Peaks. That's where we have at 7:36, Adam texting Charles. They are planning something. There is no reason why Alex should be there. And that explains why Alex wasn't responding to me and didn't let me stay there. We see that last outgoing text message by Charles Vallow at 7:37. And in fact, what we see is at 7:37 and 12 seconds, Charles sends out his last outgoing message. And at 7:37 and 29 seconds, there's an incoming message from Adam. It's not read until 12:13 p.m. What becomes important here is in this timeline, how long is Charles at the residence here? You hear in her interview how she says it's so fast. Charles comes inside. He's angry. He's jerky. And she tells him, take JJ. Go get him Burger King. They get JJ out to the car. And then she holds onto the phone. And this argument erupts, and it's just so fast. But what we know is it's actually 12 minutes long. This is not a fast incident. In this 12 minutes, Lori Vallow and her brother Alex Cox are doing their mission, and they are being like Nephi. We know at 7:49, it's over. Lori has left in Charles Vallow's car with his phone and JJ and Tylee. We know that there are 2 phone calls between Alex and this defendant after she leaves. As Charles is laying dying or dead on the floor. 7:52, 8:06, they talk. 47 minutes passes before Alex calls 911. 47 minutes to stage the scene. The police are advised when they arrive that the shooting just occurred and that CPR was given. Why is that important? Because you heard even during the interviews, the police were trying to figure out this timeline. Didn't make sense. At 8:48, almost an hour later, Lori Vallow returns. And then we see that around 9:40, she is being interviewed at the Family Advocacy Center. We know that Lori Vallow has Charles's phone that entire afternoon. You saw the PowerPoint from Detective Werther showing that her phone by about 12:36 is already her phone, Alex's phone, and Charles's phone are all in the area of Alex's house out in Sandham. You see on her records that she again calls Chad Daybell. We see that Detective Enclan calls her and leaves her a message. They don't leave immediately because what do we know? We know at 2:13, Alex is taking photos of Adam's or flight reservations from Charles's phone. Not screenshots, but photos of the phone. At 2:18, Lori Vallow, who has not told Charles's kids, his family, about his murder, is calling the mortuary. A little bit after that, they still haven't left. She's calling Chad again. And then by 3:11, we know that Charles's phone, through the GPS data, is back at 5531 South Four Peaks. And when asked about it, the defendant entirely handed over and provide the PIN. They have no problem on how to get into it. They've already looked through it. They don't need it anymore. That evening, Lori and Chad are talking all night. You can look through the exhibits and see the multiple calls of them discussing. These aren't calls to Charles's family. They're not calls to his kids. They're talking with her lover, her soon-to-be husband, Chad Daybell. So let's talk about the motives of this case. Money. We see that from the text messages and the anger that you see through them when she learns that that's been changed and she's not going to get it. Chad Daybell. We didn't go through those text messages, but you can look at them. They are already very romantically involved by the time that Charles is murdered. And it's clear that Chad knows exactly what's going on because he's asking her about the car, about the insurance. All of those things Chad knows. And then there's that religious belief system. The zombies, the disease, the possessed evil spirits. And her being like Nephi. All a reason and a way to kill someone, just like Nephi, a justified killing. There's that first call when we talk about money motive to Banner Life Insurance.
And what was the cause of his passing? Well, he was shot. Okay, so I don't know how I want to put that. Okay, all right. And I hate to ask, but is it? Yeah, you can just say yes or no. Was it a homicide? No, it was an accident. An accident.
So what we hear here is Lori Vallow being untruthful to Banner Life Insurance. We'll talk about credibility later, but it becomes very relevant that even in the smallest of things, this defendant exaggerates, minimizes, and is completely untruthful to various people. We all know that She was not the beneficiary. She didn't. But we also know that Charles Vallow was not accidentally shot. She told the police she was there. She knows that her brother intentionally shot him. Of course, they want to claim it's self-defense. There's no accident about that when you shoot someone twice. Motives for money. What we see again here is Lori Vallow talking to Chad about the motive. Telling Chad about the fact that it was changed. I just got the letter from that insurance company saying I am not the beneficiary. It is a spear through my heart. Who do you think he changed it to? Brandon, or probably Kay? He left nothing for JJ. What do we know? Again, we see that Chad knows about all of these things. And what does he talk about in that morning as you have those entire messages? Exhibit 230. It would be interesting if he got changed after he had 2 bullets to the chest. Again, as we talk about the murder, we have later in that day the message that I talked to you about. So it was probably Ned before we got rid of him. We, not I, not my brother Alex, but we did. And then the other thing in this text message that is of importance is the fact that Lori Vallow knew a month before she went to Social Security how much money she was already going to get for the death of Charles. Here she says, I will still get the $4,000 a month from Social Security. When we talk about that motive and the anger by this defendant over not being the beneficiary, we know that even on July 28th, so 10 days later, she goes into Charles's computer to find the change of beneficiary form. She texts that to Chad to show him, and she sends it to Kay and confronts her about it. Money. That's what she wanted. And Chad. So let's talk about Chad. The affair with Chad Daybell. We know that she knew him as far back as November of 2018 when she came here, when he came to Arizona and stayed at Lori's house. You were told by Detective Duncan that there were recordings on her Lori for Style iCloud account of Chad Daybell here in Arizona for that Preparing the People conference. You also heard that in the Lolly time, the later account that was created later, that in March of 2019, there were screenshots of flights to Idaho and back to Arizona with both Lori Vallow and Chad Daybell. This is during that time when she disappeared and Charles was taking care of JJ, and she's off flying to Hawaii and Idaho, living the good life with her soon-to-be husband. And then, of course, we know that come November 5th, she actually marries Chad Daybell. That KK Walker email address, this was that June 29th, big change. What do we know? That on April 21st, she created that account. She used her own phone number in creating it. And then she sent messages to Chad Daybell, brother Daybell. You have that exhibit. She pretends to be Karen Walker and invites him to Houston, because that's where she is at that time. She offers to use Charles's money to fly him out there, and that he can stay at the house with her and her husband. In June of 2019, we see that Lori again uses that same account, but this time she pretends to be Charles and invites Chad out to Arizona to help him with a book. And again, in Exhibit 289, you have those letters. Charles finds those. And he lets everyone know he did. And he confronts Tammy, lets her know. Confronts Chad, lets him know. And he certainly lets the defendant know that he knows. And now the jig is up. We see in these text messages that were recovered from the iCloud accounts, whether they're under the Bubby context or under the Melanie 2 contact, this relationship between Lori and Chad. If you want to read the story, it kind of mimics them meeting in November, hooking up in hotels, and discussing their love for each other. When we are talking about a motive and a person who wants money and who has not worked for 13 years, who has had her husband pay for her homes, her phones, her cars, allowing her to go to the temple and work out and go to lunch and restaurants. This is a big change in life if she loses all of this. But if she gets $1 million, it's not so big of a difference, along with that Social Security she'll be getting. And then obviously we know that once Charles was out of the way, Lori and Chad were able to get married. But what about those religious beliefs? Everyone that Lori knew, who she expressed them to, told you that they were not in line with the Church of Latter-day Saints. Everyone told you that she said things like she didn't need to repent, she didn't need forgiveness, she could do whatever she wanted now, that she was in a celestial state, translated, that she is spiritually and physically changing, that she's above the priesthood, that she knew who was dark and evil. You saw those text messages, both about Charles and heard from people, as well as about Brandon and Zach and Adam. People who were helping Charles were also dark or Z's. And ultimately, what did we learn? That she associated herself with Nephi, a prophet, a holy man, who was justified and asked by God to kill Laban because he was an evil, wicked king who had the tablets that God wanted him to go get. Lori was just like that. She was justified in her killing. We heard from her brother, Adam, that their relationship had ended when she told him some things about her beliefs that he disagreed with, that she was turning into that celestial state, that she didn't need to eat, that she had more authority than the priesthood.
Yes.
You yourself personally, were you aware of Lori having outside? Lori having any beliefs that were outside of what is accepted by the LDS religion?
Yes.
Can you tell us what you were aware of that you knew to be outside the LDS religion?
Lori told me that she was in the process of translating from a mortal human being to an immortal human being, a celestial state.
That's something that the LDS religion supports?
I haven't heard of it in that it's happened here on Earth yet.
Serena Sharp told us about, again, the not repenting and Lori changing physically and spiritually.
Members of the LDS Church?
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church.
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the name was?
Yes.
What was it?
It was Ned.
N-E-D? Ned?
N-E-D.
Now, Serena Sharp was someone who met Lori in November, texted or talked with her for a while, and then was invited to that girls' weekend. One of the jury instructions you're looking at, and we'll talk about more though, is the credibility of a witness. Serena Sharp has no dog in this fight. She knew Lori for a little while. She was invited to, I'll call it the inner circle. The defendant told her some things that went against her religious beliefs. And she said pretty much after that, the defendant stopped talking to her. Now, how do we know she's being truthful? Well, we see Ned in lots of text messages. This just helps tell us that this is something Lori was telling lots of people, that her husband is possessed by this evil spirit, Ned. And we learn later that, like Nephi, she can get rid of him. Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned, was she explaining that this evil spirit was now in the body of her husband?
I don't know if she used those exact terms, but that was the impression I got, yes.
So the word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
The other thing that Serena Sharp told us was Lori using that term zombie. You remember how upset the defendant got by her saying that. But again, why would Serena make up any of this? She has no reason to. What she recalls is that that is a term that this defendant used when speaking of people like her husband who were possessed by these evil spirits. We heard from Christina Atwood as well, the same concept that Lori Vallow repeatedly would say. Did she tell you, as well as the other women who were at this meeting in February, that her husband was possessed?
Yes.
Okay. So it wasn't just you in a private conversation.
Correct.
She was open about it.
Yes.
So again, we see this ongoing timing of Lori Vallow talking of her evil, dark husband, who she later is authorized under her religion to get rid of. We know as well from Christina Atwood that there is a progression of these beliefs becoming more deviated from the LDS religion as she is meeting with her between February and June when she finally hears those words. From the time you started meeting with these gatherings in February through to June, did you start to see sort of a progression of things that Lori was telling you that seemed outside of your faith?
Yes.
Did she make statements to you that you believed went against your religion?
Yes.
Did she at any point tell you that she did not need to repent anymore?
Yes.
What is that? What is that meaningful to you in your religion?
We believe that every single person outside of Jesus Christ has reason to repent.
Other than Lori Vallow, according to her words to multiple people. So let's take all of this, the motives and this timeline now, and talk about some of the jury instructions and all the evidence that supports proof beyond a reasonable doubt that this defendant is guilty. I want to start with talking to you about direct and circumstantial evidence. You have a jury instruction that tells you that evidence may be direct or circumstantial, that direct evidence is the testimony of what a witness saw, heard, or otherwise sensed, and circumstantial evidence is proof of a fact or facts from which you may find another fact. You're told the law makes no distinction between direct and circumstantial evidence. And this is relevant. The witnesses have often been questioned. Did you see, hear, or do that? What you are told is you can actually use circumstantial evidence to convict anyone. But let me give you an example of this. Imagine you are sitting on a beach. Just you, it's quiet. Off to your right, there's some rocks and you can't see around that. While you're sitting there, a person walks by, you watch them walk by and they go around the rocks and you can't see them anymore. And then someone runs up 5 minutes later and they say, hey, did you see someone come by here? You say, well, yeah, I saw them walk that way. That is direct evidence. You saw it. Now imagine you're on that same beach and it's completely empty. You close your eyes for 5 minutes, just relax. Before you closed your eyes, the beach was completely pristine. And when you open them up, now you see footprints. You can see the toes facing off to your right, the heels, and you see them go all the way around the rocks there. Somebody again runs up 5 minutes later and they say, hey, did someone come by here? And you go, well, I mean, I didn't see them, but they must have gone by in the last 5 minutes because you can see their footprints. They went that way. That is circumstantial evidence. You can infer from that that someone went by and where they went. The burden of proof. The state has the burden of proof, as we absolutely should. So let's talk a little bit about what it is and what it is not. You're told that the burden of proof is proof beyond a reasonable doubt. And the instruction tells you that that leaves you firmly convinced in the defendant's guilt. You're told there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him or her guilty. So I want to start by saying what proof beyond a reasonable doubt is not. It is not proof beyond all doubt. It is not proof beyond all conceivable doubt. It's not proof beyond all possible doubt, and it's not no doubt. You're told that there are very few things in life we know with absolute certainty. So just because someone says, what if? That is not a reasonable doubt. What you're told is it's proof beyond a reasonable doubt. As we go through the evidence and apply it to the crimes, we will show you that there is no reasonable doubt as to this defendant's guilt. So let's start with the crime itself. Conspiracy to commit first-degree murder. There are 3 stages in this, or 3 things the state must prove. 1, that the defendant or her co-conspirator caused the death of another person. Well, we know that Alex Cox shot and killed Charles on July 11th of 2019. Alex called 911. Alex indicated he was the shooter. He was the only one home. It was his gun. His credit card or debit card was in there with the gun. And we know that Lori told police that her brother killed Charles. So we know that he caused the death of. So that. 2, that they intended or knew that she or a co-conspirator would cause the death of another person. When we are looking at this case, we are looking at the defendant's words, actions, and motive. The words and actions of having her brother Alex come over on the 10th with a gun so that he would be there when Charles came over to pick up JJ. The actions that day of taking Charles's phone, ensuring that he could not leave, that he could not take his son to school. The defendant told the detectives how angry and screaming Charles was about the phone, but she didn't just give it to him, throw it at him, tell him to get out, whatever you might do. She held onto it and told the police that she walked away with it as he's trying to grab it. The defendant's actions and words show us that she is the only reason why Charles stayed in there and the only reason why Charles was shot. Then there's those 12 minutes. Defendant tried to pretend that this was a quick, angry scuffle. But Charles is there for 12 minutes. The defendant is there for 12 minutes. Alex is there for 12 minutes before she leaves. We look at her actions when she came back. She told the police her brother was hit in the head with a bat. She never asks how he is. She's not concerned about his injury. She's not concerned about her husband being dead on the floor of her house, her child now without a father. The lack of words that she said there and her demeanor show again that she was well aware of what was going on and part of this incident. We look at her words to Chad, that Charles changed his life insurance policy before we got rid of him. They show her intent to kill Charles. And again, we look at the motive, money and Chad. When did this happen? The first time Charles came back into town after he found out about the affair. Finally, the state has to prove that the defendant or the co-conspirator acted with premeditation. So I'm going to talk to you about premeditation. You have a jury instruction for it, and it tells you that the defendant or the co-conspirator intended to kill another human being or knew she or the co-conspirator would kill another human being, and that after forming that intent or knowledge reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. You're also told an act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. It's where you remember those 12 minutes and the calmness of her walking around with that phone and her demeanor. You're told the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. So I'm going to give you an example. It's a lot of legalese, and then we'll talk about what we really have here. So imagine again, you are driving your car. You do every day. And you're coming up to an intersection and you see the light turn yellow. And in that second you think, do I want to run it? Or do I want to slam on my brakes and hit it? Stop before I go into the intersection. You think about that, and then you decide, I'm going to slam on my brakes, and I'm going to stop. That is the time it takes to reflect. That is the time it takes for premeditation. But we have a lot more than this because we have planning, not just premeditation that morning. So when we talk about the premeditation that we see, it starts at least back in June, when we have Christina telling us about Alex Cox saying that he wanted to kill Charles, Lori having no reaction to that, and instead talking about drugging Charles. Did you hear Alex making some comments?
Yes.
And you told us that they made you uncomfortable. What were these comments?
He stated he wished that he could just kill Charles.
Okay. Was Lori around when he was saying this?
Yes, one of the times.
Okay. So he said it more than once.
Yes.
Can you describe for us sort of his demeanor when he's saying this about wanting to just kill Charles?
It was jocular, just as I probably was standing up and just talking about it pretty loudly.
And you said one of the times that he said this, it was around Lori.
Yes.
Did she react in any way to hearing her brother say that he wished he could just kill her husband?
Not that I recall.
By July 9th, or when we start having this planning that we're talking about, we know that Lori Vallow is living in a house paid for by Charles Vallow. We know from even her statements to Detective Enclan that she doesn't like Charles, is what she says, but Charles won't file for a divorce. We know from her words and text messages that she wants to be with Chad Daybell, but Charles is her cash cow. She hasn't worked. He pays rent, car, cell phones, her travel. And so as far back as June 9th, we're already hearing that Alex and Lori would like to not just get rid of Charles, but kill him. But if you think that June 9th wasn't the beginning of this planning, this idea, this concept that Lori and her brother have of getting rid of Charles, this evil, dark, possessed person, that we know on the 9th that there is definitely a plan by this defendant. And we see that through those text messages with Melanie, with Summer, with Alex, where she speaks of the mission, where she talks about telling Melanie, you can't leave. You got to pretend to be sick and stay here and keep track of Brandon so he doesn't come help Charles. He can't be in the picture. We need to stay here to defend ourselves from an intervention. The 10th, again, we have Melanie who is talking to her and saying, that she wants to just go to this wedding. And what does Lori tell her? No, you have to stay here for the mission. The mission of stopping an intervention? No. As we continue through the 9th, we see Lori getting everyone lined up to help her. Alex, where he again is told that he will be like Nephi, just like her. Now Lori tells him it's an intervention. Everyone knows, Adam told you what's an intervention? It's talking to someone. It's common language. But that's not what the defendant wants to happen. She doesn't want Charles to divorce her and lose his money. She doesn't want this intervention to happen where she loses her. What she wants is to be like Nephi and get rid of her husband.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He is a prophet, very faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him. And Nephi was told to kill Laban.
Who was he told by?
The spirit, or God.
So God was using a Holy Spirit to tell him to kill Laban? And
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
You heard from Detective Duncan that everyone he spoke with gave this same story. And again, the defendant questioned others about this story. But what we've heard is from Detective Duncan and from Adam that Nephi is justified killing. When we think about her religious beliefs and what she's been telling people about not needing to repent, about telling people who is dark and evil, a zombie or a Z, that she is above the priesthood, it makes sense that she feels justified in determining who should live or die, just as she told her brother on the 9th. And we know that in fact we're talking about a justified killing because Alex brought a gun over. He didn't bring the Book of Mormon to talk to Charles about something. He didn't bring a friend to try to record Charles saying something. He brought a gun with him. And then he waited there for his sister's husband to come into the house so he could kill him. What we see is a very planned out, premeditated murder. But let's talk about some additional premeditation. Again, as we're looking at Summer, we see on the 10th that Lori is having her sister update her on where Adam and Zach are staying, so she knows they're not with Charles. They're not coming over. They're not going to be interfering with their justified killing. And there's that 12-minute time where the defendant desperately wanted to rewrite the timeline as they told the police that day. This just happened. It was very quick, but it wasn't. It was 12 minutes. Charles arrives at 7:37 and Lori leaves at 7:49. During this time is when that plan, that premeditated murder occurred. So let's talk about that as well. The evidence at the scene, the physical evidence, supports this premeditated murder. Alex fired 2 shots. One of them went through Charles' center mast, exited out his back, and went into the floorboard. The second one, Charles was on the floor, on his back, bleeding out, still able to move, and we know that because he had blood on his left hand, and he was executed as he lay there on the ground. In that time, when we talk about premeditation and reflection, as Adam had to move his hand down, reposition the gun, and discharge and pull the trigger one more time, that is premeditated first-degree murder, no matter what you believe before that. Again, when we talk about that physical evidence, we saw the fact that the location of that bullet defect in the ground matched right under Charles's left shoulder. And we heard from Dr. Baumgartner. Dr. Baumgartner told you that this was a classic shored wound. And no matter how many questions could be asked about him of maybe a bamboo shirt might stop a bullet in one location but not in another, or how many matrix-like hypotheticals where maybe Charles bounced back up and then on his way down, the bullet slowed down through him and waited till he hit the ground again before it exited. Dr. Baumgartner told you, no, those hypotheticals, those issues did not make sense. He's never seen a t-shirt stop a bullet in one location or at all. And we know Charles didn't bounce because we know he had no injuries to the back of his head. This also tells us a little bit about the shooting itself. When Charles was shot that first time through center mast, he did not fall straight back and land onto the ground laying there on his back. If he had, he would have had bruising, abrasions on the back of his head when he hit the ground. He didn't have anything on the back of his head. Where did he have abrasions? On his knees. When he fell to the ground after being shot, do we know how long it took him to roll over, to fall onto his back before he was then shot a second time because he's still alive? You heard it could take up to 2 minutes for Charles to have died, and then he could have spoke and moved during that time period. What we do know is that he eventually ended up on his back. And while he was on his back is when he was shot the second time by Alex. This defendant and her brother in that house waiting and making sure that Charles was dead, murdered, executed. Words, actions, motive, and physical evidence all tell you what happened that morning. So let's talk about conspiracy. And I know there are a lot of layers here, and I'm just building them up for you. You're told in your jury instructions that conspiracy requires proof. One, the defendant agreed with one or more persons that one of them or another would engage in certain conduct. So again, we look to Lori Vallow's words. What she had been talking about for months, Charles being possessed, being dark, wanting to kill him, the discussion on June 9th, poisoning him or drugging him previously. And then when we got to July 9th, it is all coming to a head. We will be like Nephi. Her actions, having Charles come to the house, instead of him staying there, she had him stay away. Why? Because if Charles stayed at the house, couldn't have Alex come over with a gun and be ready to shoot him, right? You got to have him come in. Her actions of inviting her brother over with a gun the night before so he would be there. She knew when he would show up. He texted her, I'll be there at 7:30, pick up JJ. But most importantly, why did Charles stay in the house? Lori told the detective that Charles initially was like, oh, I'll just stay here for 20 minutes and then I'll take JJ to school. Well, she wasn't going to kill him in front of JJ. No, take JJ to Burger King. Get him out of the house. Go put him in the car. And he does that. But then she takes his phone. And she won't give it back. What she told the detective was, before this alleged Tylee bat, whatever thing you want to talk about there, that She had Charles's phone and was asking him about texting Adam. Of course, that's interesting because how would she have known that? We know she had the phone actually for a while before she did that interview. She tells the detective numerous times that Charles is telling her to give him back his phone, and she will not. That she's walking around. He's trying to get the phone. She won't give it to him. Why? Because she needs Alex to come out. He brought that gun over for a reason. So she agreed with one or more persons, her brother, Alex, that she intended to promote or assist the commission of such conduct. Well, of course, we know both the promote. She is the one who on the 9th said, we will be like Nephi. It's time to stop this whole thing. Charles trying to take my temple recommend, all this stuff that's going on. Time to kill him. And of course, she assists by ensuring that Charles stays in the house when she takes that phone. And of course, they knew that it would constitute first-degree murder. That's what Nephi did. Only unlike Nephi, where it was justified, here, ladies and gentlemen, this murder was not justified. Finally, think about the demeanor when you're thinking about, again, words, actions, motive, and demeanor. When Lori comes back to the house, she is very, what did we hear that word many times? Nonchalant, calm, no questions about her brother, no questions about her husband, no questions about the house, just laughing about her neighbors. She is in absolute agreement with what has happened. She knows what's happened and she's calm and good with it because she doesn't need to repent. She is able to determine who should live and die, and she has done that. So when we talk of the scope of conspiracy, you're told that to prove a conspiracy, it is not necessary to show a formal meeting or express agreement. But we see that from the 9th in that conversation that she and Alex had, where she tells him, you are going to have to stay near me for the next couple days, and we will be like Nephi. You're also told that a conspiracy may be inferred from circumstances showing a common criminal objective. So, because you don't have someone who says, I heard them say, we shall conspire. You can infer that from the conduct of what happened on the 9th, the conduct of what happened on the 10th, and the conduct of what happened on the 11th. All infer to you a conspiracy of Alex coming over with his gun to shoot and kill Charles. As we again look at this in this conspiracy, again, we're looking at the same words and actions. March, Charles is no longer there. There's just an evil spirit in his body. June, Charles is still possessed, and now Alex is saying he wants to kill him. Lori is fine with this, and she says she's drugging him or had been drugging him. And then 2 weeks before, all of a sudden, Charles knows Lori's been having this affair. Lori's words, actions, motive, and the physical evidence. Conspiracy again, we see that Lori and Alex know exactly when Charles is showing up. Alex doesn't go to the door according to Lori and confront Charles or tell him we'll send JJ out and you can leave with him. The world is so difficult. How hard would that be? Bring JJ right to the door and let him leave with his dad. No. You aren't going to shoot him outside. You want to make it look like self-defense inside. As you go through this and we think about what's going on, the defendant doesn't even care. She wants her husband killed so bad that she's willing to let her brother bring over a loaded gun in an unlocked gun case in a house with a 7-year-old autistic child. That's fine. When the defendant was questioning Detective Enclan, she was talking about how hot it was outside. JJ's out in the car. But she has no problem with an unlocked gun in the house with the kid, and she's worried about her child out in the car. She's not. We know that because she's the reason Charles doesn't go back out into the car and leave. She keeps him there in the house. She is why JJ's out in the car alone. She has to keep him there until Alex comes out and can shoot and kill him. When we talk about that premeditation, obviously we're talking about that message. We know from the 9th on, they are premeditated, they are conspiring, and it's all heading to July 11th. We look at the timing of this, and this is actions and non-actions. Charles is in the house for 12 minutes. After those 12 minutes, they wait 47 more minutes before they call 911. Why? To stage the scene. No CPR is performed. They wait for Charles to be dead, and then they talk during this time period. They talk. They could call 911, but nope, they're going to just talk. So again, you're looking at their actions, what happened and didn't happen, and the motives. There's the gun that was used to kill Charles. We're going to go through a couple of these exhibits, some of what Lori said, and it's exhibits 192 and 197, where she again says that Charles came over and said he was just going to hang out at the house for like 20 minutes, take JJ to school. She, of course, tells him to go. And when JJ is out in the car, she has Charles's phone, and she won't give it back. And no matter how much she says that Charles is screaming at her to give the phone back, she won't. And all of this conversation about Charles demanding the phone back is prior to her statement to Detective Enclan that Tylee comes out with this bat. This is all her doing. This is her as an accomplice assisting and promoting this murder. Lori is setting up Charles so Alex can shoot him.
And with JJ?
And so he put it in the car,
Okay.
in the driveway, and then he came back in, right? So I kissed JJ goodbye. He came back in, and his phone was on the counter, and I had his phone. And he was like, give me my phone. And I was like, why don't you show me your text that you've been texting, blah, 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 you know, whatever. Because he's like acting really weird, like he's plotting something against me. Like, I'm like, why are you even here? Like, what did you come here for? You know, he's been talking to my other brother, and my brother came into town at the same time last night. And I haven't talked to my brother in a while, my other brother. And I was like, and so he was texting him on the phone when he first got to my house. And I'm like, why are you texting Adam? Like, do you even talk to him? Like my other brothers.
So when you listen to these clips and the interview of Lori Vallow, you have to put into context, this is 9:52 in the morning when this part of this interview is occurring. And she's telling the detective that she confronts Charles about texting her brother Adam. Now, she's had the 47 minutes she's been driving around, and then that time at the house when she's waiting outside to learn all of those texts and what's been going on between her brother and Adam and Charles. And so she is now mixing this in to her interview. And so when you're listening to her interview, we know she's trying to work out this, what happened, how did this go? you can watch her demeanor as well. And as you're going through this, see how she's just telling a story here, like what happened, almost chuckling about it.
Okay. So this morning he comes back in and.
He comes back in, I wouldn't give him his phone, he was screaming at me to give him his phone. He was very worried about whatever was on his text that he did not want me to see. And so I was just holding it there and he was screaming at me. And I was kind of walking towards around the house with it so he couldn't get it. He's like reaching for it and stuff like that.
So again, JJ's in the car, Tylee's not out, Alex isn't out, and she is making sure that he doesn't leave. She's walking around the house, holding his phone, refusing it to give it to him, making sure her autistic child is sitting out in the car even longer so that she can ensure that exactly what they've been planning happens, that Alex has time to come out with the gun that he brought over and shoot and kill Charles. This defendant is the only reason why Charles didn't leave with JJ. This defendant is the one who provoked Charles by taking his phone and refusing to get it back. This defendant is the one who ensured that Charles was inside without JJ so Alex could shoot him. And this defendant is the person who set up Charles so that her brother Alex could shoot him. Let's talk about staging the scene. We know obviously from the first responders that when they arrived, no CPR was given. You heard from Officer Wierzbecki that when he felt Charles's neck, he thought he was dead already, but they still let the first responders in because they've been told CPR had been given. And what do we know? That they arrived within a few minutes. No one had ever tried to save Charles. No blood had been pushed out of him from CPR, whether strong or light. He had been dead for quite a while. His skin was mottled when they started cutting open his shirt and looking to the back, and lividity, the blood pooling, was occurring already. So they kind of knew something was off with that timeline. So what about the scene itself? The bat. It is placed to the right of Charles to look like he was using it. Got shot and it went flying behind him. Well, obviously we've heard from Kay, Charles's sister, that he was left-handed. We know from the blood evidence on his hand, he was left-handed. There's no damage to that mirror. There's no damage to the drywall. There's no damage anywhere, like this bat is being swung around in this horrific fight that's going on of grappling. The injury to Alex Cox's head. You heard it was a small 1-inch cut that he was using a paper towel to pat, and at times, as you watch that Exhibit 1, rubbing it, making sure it stays bleeding. There is no blood at the scene from this giant grappling thing going on that Lori Vallow wanted them to believe. His head is bleeding and they're grappling around and he's being beat with this bat, and yet not one drop of blood on the floor. Not one drop of blood going down the hallway when he put that gun away. Not one drop of blood on the gun itself. And then the shoes, left by the door to look like Lori Vallow had run out in fear after this horrific incident that they planned. But we know from the Walgreens video is that she did enter the store with shoes, something on her feet. So we're going to go through. We know Charles, again, left-handed.
With your brother. Yeah. What position did your brother play?
He was a pitcher. He was very, very good. He was a left-handed pitcher, and they're very hard to hit against.
Okay. Did he bat right or left-handed?
He was left-handed.
Did he do everything left-handed?
Yes.
Left-handed?
So we know that Charles batted left-handed, not right-handed. And what we know is Lori Vallow had a story about how Charles was using that bat. And it becomes very important as well when we're talking about the staging of the scene. This is Exhibit 193.
Yeah, she was outside.
And then what happened?
Then they got up from that, and my brother had like stepped back, I guess, and then Charles was coming with me to that and yelling at me to give him his phone still because I had it in my hand. It was all really quickly, and then when I went around kind of in the circle, then my brother was there.
When you said when you were going around and he was coming at you with the bat, how was he holding the bat?
Just like that, like backwards.
Like he was swinging it, swinging it backwards? He would have done like
he would have swung it backwards at me, not frontward.
Okay.
So Lori Vallow, detective, and planned that Charles is swinging the bat backwards. Now, if the bat was like this when he was shot, the arm would have been shot. Covers his center mass. So we know he wasn't here. So if he's out here, where would the bat go? Down, out, somewhere that way to his left. It would not end up thrown up above him. And if it wasn't there again, Charles would have been shot through the arm. Obviously, Alex forgot that Charles was left-handed. So when he placed that, like he was coming at him with a bat, their stories didn't quite match up with the evidence. So if we rely on Lori's story of how Charles was holding the bat, then there's zero way that that bat would end up where it ended up. And again, we know he's left-handed from not only Kay, but his own admissions of that blood on his hand. So we see the scene is staged, this bat that is so necessary to try to ensure this justified killing is legally justified and not just spiritually justified. When we talk about the scene as well, and you're looking at where Charles was, at least when that second shot went through him, you can see in the photograph to the right, the shot to Charles's chest, right between his nipples, and the shot to Charles's abdomen down lower. We know that that first shot through his chest, that Charles would have been facing a little more towards the open area there where we see the hallway and the kitchen. We know that because there was the bullet trajectory Detective Cruz told you about that entered that far east wall. We know there was stippling, and so the defendant would have been, well, her brother would have been within 2 to 4 feet of the muzzle of that gun within Charles, 2 to 4 feet. We know from the lack of that injury to the back of his head that he didn't fall straight back. We know from the blood on his hand that he was still alive after he was shot. And we know the lack of stippling for that shot to his abdomen and that trajectory, and even the defendant's own statements that she saw her brother at Charles's feet, that he would have stood there at Charles's feet when he fired that second shot as he was laying on the floor. You have the bat, Exhibit 249. You can look at the edge of it. You see the photograph of the edge of it. There is no blood and no damage to this bat. Regardless of how many times the defendant was hoping that blood was invisible, we have all cut ourselves and seen that blood is red. And there was no blood on this bat. There is no blood on this bat. There is no damage to this bat. So you have a semi-professional baseball player who has a bat in his hand, and he sees someone with a gun and doesn't beat him with it, take his head off with it, knock him unconscious with it. Instead, all we see on this bat is 0 damage and 2 partial prints. No prints of a body or smushed skin on it, someone that's sweating from a fight that's left a large arm print on it or anything else. Nope, just two partial little prints on it. When you think about what is there and what isn't there, does the evidence of this bat fit in at all? It doesn't. We look at Charles's watch. No damage to it, no scratches to it, no dings to it as he's grappling on the floor like Lori wants you to believe. We know that at some point, Charles is standing and shot, and we know that final shot, he's on the ground. We know he fell to his knees at some point. And when you look at that physical evidence and the lack of damage or anything on that bat, again, what makes sense is that Charles fell to his knees after that first shot. We know that there is 12 minutes where the defendant and her brother are still together there, so that Alex can get this 1-inch cut to the back of his head that's barely bleeding, that he uses a paper towel to dab at and rub. The shoes that the defendant ran out of on her way out. You have the exhibit. You can see black straps across her toes as she enters and exits the Walgreens. And then you see that she's wearing the flip-flops when she comes back to the scene. What do we know? That the police did not search Charles's rental car. Credibility. You are given a credibility instruction and you use it for everyone, including the defendant. You're told that you really evaluate people the same way. You're looking for any inconsistencies in their stories, any reasons why they may have a motive or bias to lie, any prejudice they may have, and then you look at everything in light of reason, common sense, and experience. When you think of the testimony of the people who've come here and talked to you, Christina Atwood, Serena Sharp, Nancy Jo Hancock, Adam Cox, Dr. Bumgardner, the detectives, Robin Smith Scott, Mark Zari, what benefit do these people have in being untruthful to you? They have body cameras, they have prior documents, and they have memories of what this defendant said. But the credibility of Lori Vallow is something you do need to consider. And you start with her demeanor that day where she wasn't worried about anything when she arrived. Her brother has allegedly been hit in the head with a bat by her husband who plays semi-pro ball. She doesn't even worry about him. She knows he's not hurt. He's fine. And why does she know that? Because that was staged. When she's there and we see her on body cam arriving, she's just nonchalant and calm. And I know the defendant wanted to make sure that it was clear that everyone else was calm, but no one else had just allegedly seen their husband get shot and killed by their brother. When you were looking at the reasonableness of her testimony, you have to consider it in the light of reason, common sense, and experience. And the way that she was acting and reacting that day, as well as her own statements, do not fit the evidence, do not fit the physical evidence. And you will see her credibility throughout this whole case has been questionable. Her credibility with Social Security. What did we learn? That on July 11th, she tells Detective Enclan that she and Charles are separated. Exhibit 187. We are not living together. Charles rented her house. We're separated. But on August 12th, when she needs to make sure she gets some money, she tells Social Security, when they ask, are you living together at the time of death? Yes. You also learned that she was not truthful with Social Security when she got remarried. She did not tell them about that either. So we know she's been untruthful to Social Security twice. Why is that relevant? Because you're judging the credibility of Lori Vallow throughout all of this. Life insurance. We know that she said Charles was accidentally shot. We know that was not true. She wanted to make things seem like she had nothing to do with the murder. But we know that Alex Cox intentionally shot Charles. Whether or not she wants to claim it's self-defense or not, there was nothing accidental about shooting him twice. Then that second call to Banner Life Insurance, where she tells Robin Smith Scott a few different things to garner sympathy, and she asked her if she could do anything about the change in beneficiary.
I really can't give too much information, but I can tell you that the beneficiary was changed in March of this year. Okay. Okay, I'm trying to figure out what he was doing since we have 5 kids and we've been married for 15 years. Oh, I'm sorry.
So Lori tells this woman, we have 5 kids, which if you want to count them all and admit that 3 of them are adults, then okay. Really, they have one kid in common. Tylee, you learned, was actually getting Social Security survivor benefits from her dad's death starting in 2018. Lori's son, Colby, isn't living with them. Charles' son's never lived with them. Why does she say these things? She can't help it. She just wants to just make herself seem better than she is. What about the credibility of her interview, even during the police interview? We talked about a few things, but one of the things she told the detective.
That I didn't file anything or whatever. And then he filed something against me and said, I'm only going to get supervised visits because I'm crazy and blah, 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 you know, the story. And so I just didn't talk to him for like 30 days and let him take care of him and let him see what I've been doing.
So again, she can't even be honest and say 2 months. It's got to be like 30 days. I was kind enough to just leave my husband with my son for 30 days. What we know is that Rory Vallow was gone a total of 78 days, 58 while she's flying to Hawaii, going to Idaho and back with Chad. And who's taking care of JJ? Charles. And Kay is coming here regularly to help take care of JJ, to help run the business. And then eventually on March 28th, that's when Charles finally decides he hasn't been able to find Lori. He doesn't know where she is. He's going to move to Houston to be closer so his sister can help him more easily. And this is when Lori finally shows back up. So again, even the simplest thing of just trying to be honest about how long she's been gone, she has to minimize it and make herself seem better.
With your cross.
The shoes. Oops. If this will play. When she was questioning Detective Enclam, she was asking her if it was hot in July and if she would need shoes to go take her son to school. But of course, what we know is that we saw her with those shoes on as she went into Walgreens. So again, it's continued trying to garner sympathy and just being untruthful about whatever she feels like being untruthful about. And then we look at the credibility in that timeline, that body cam.
You know, now that you're not in Santan, this is your home.
Right,
Yeah.
right.
Okay.
We just moved in.
Gotcha. How long have you guys lived here?
Sorry?
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah. Okay.
That's why the neighbors took us.
Gotcha.
Like, hi neighbor, sorry.
Are you working?
So here she is, 47 minutes after leaving the house, laughing and smiling with the detective about the fact that her husband is dead inside the house. Her brother is sitting on the curb, allegedly with this very serious injury from a baseball bat. When you look at that credibility of the defendant, you have to look at everything together and what fits, again, with the physical evidence and what doesn't. Finally, let's talk about the justification defenses. What we know is that Lori Vallow thought she was like Nephi, that she was justified in killing Charles. That her brother, who was supposed to be like her, was also justified in killing Charles. But Lori Vallow is not justified under Arizona law, nor is Alex. So let's go through the different justification defenses. First thing that you have to consider for every one of these, self-defense, defense of a third person, or crime prevention, is the non-justification for use of deadly physical force. You're told if a person is not justified in using or threatening physical force or deadly physical force against another in response to verbal provocation alone. So Charles yelling and screaming at her to give his phone back does not justify you shooting him. Or a person is not justified in using or threatening deadly physical force if the defendant or co-conspirator provoked the other's use or attempted use of unlawful physical force. So we know here, Lori provoked Charles by taking his phone and refusing to give it back. So again, when we look at every one of these defenses, you'll see not only do they not apply, but none of them is the defendant entitled to. This is not self-defense. In self-defense, you're told that a person, a reasonable person, can use deadly physical force if they believe that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in this situation. We know that Lori Vallow used Charles's phone to get him to come back inside, and she used his phone to keep him inside and give her brother time to come out and shoot and kill Charles. We know from the physical scene itself that Charles did not use a bat. We know from the physical evidence of Alex's 1-inch cut to his head and the lack of blood or concussion, the lack of damage to the mirrors, the walls, the location of the bat in relation to Charles, they all tell us that Charles did not use a bat. We know that Charles was a semi-professional baseball player. This would not have ended that way if he had had a bat. But even if you somehow think that he did have a bat and he was swinging it at Alex, the defendant, whoever, he still was not justified in shooting him when he was on the ground. It has to be immediately necessary to protect against another's use. When Charles is on the ground and he is shot that second time, there is no threat to anyone. And so that is not self-defense.
Counsel, I need to give my court reporter a break unless you think you'll be done in the next 5 minutes. Okay, go ahead.
When we look at the physical evidence, again, we know that Charles was on the ground, shot, and so this is not self-defense. And we know from the physical evidence at the scene, projectile into the floorboard, this is not self-defense. Third party. You're told that a person is justified in using or threatening deadly physical force in defense of a third person, I presume here Lori Vallow. If a reasonable person in this situation would have believed that deadly physical force was necessary to protect against another's use, again, of unlawful deadly physical force against a third person, and they used only what was necessary for a reasonable person under the situation. What do we know? Lori Vallow told Detective Enclan that she wasn't even in the room when she heard the shot, that she had gone around into the kitchen. Who's he protecting at that point? What third person that's no longer there is he protecting? You can't protect against a future, what might happen. or what already occurred. It has to be now. And Lori Vallow herself put herself outside the room when her brother shot Charles. So there is no third-party defense. But again, the same thing applies. Even if you thought so, that second shot removes any possibility of being justified. Crime prevention. It's the exact same thing, only in a slightly different stated way. But like self-defense, it allows a person to use deadly physical force against another to the extent a reasonable person would have believed that deadly physical force was immediately necessary to prevent Charles from committing aggravated assault against Lori Vallow. We know she's not in the room. Even if he had that bat and had been coming at her and then she left the room, that crime is over. And again, even if you believe he had the bat, you cannot shoot him while he's on the ground. That is not what crime prevention permits you to execute a person. Finally, there's mere presence. You're told that guilt cannot be established by a defendant's mere presence at the crime scene, mere association with another person at the crime scene, or mere knowledge that a crime is being committed. Lori Vallow wasn't just present at this crime scene. She brought her brother to the crime scene. She ensured that he brought a gun with him. She ensured that JJ was outside, and she ensured that Charles stayed inside. She was not merely present. She was a person who was actively participating in this crime. Ladies and gentlemen, we have talked about the evidence in this case. Evidence that was presented to you through witnesses who took the stand and exhibits that were admitted for you to review. Remember the evidence of Lori Vallow's motive. Charles's life insurance, Chad Daybell. Remember Lori Vallow's own words of wanting to get rid of Charles, of drugging him, her acceptance of her brother's statements that he wanted to kill Charles, how she used Melanie and Summer to plan her mission and ensure that Charles didn't have help from Brandon or Zach or Adam. Her words to Alex about it all coming to a head, that he had to stay near her and they would be like Nephi, justified in killing Charles. And finally, her words to Chad Daybell on July 18th, confessing to the killing when she said Charles had changed the life insurance before we got rid of him. Look at her actions and demeanor, having her brother come over on the 10th to her house with a loaded .45 caliber handgun, creating the one and only reason why Charles stayed inside the house, why he didn't just take JJ to school. The 12 minutes that Charles is at the house before Lori leaves in the car, the 47 minutes after that before they call 911, her demeanor when she comes back, not caring that anyone has been hurt, her demeanor on the body-worn camera, during her interview, what you heard about during the drive. Think about her credibility, how she cried for you in her opening statement. You certainly didn't see her cry on that body camera footage. You didn't hear about her crying as she was being driven to the Family Advocacy Center, and you did not see her cry in her interview. Finally, think about the physical evidence that proves that Lori and Alex staged this scene, that Charles was never in possession of that bat when he was shot by Alex or either of the shots, that instead he was executed that day for this defendant's benefit. The physical evidence disproves beyond a reasonable doubt that Lori Vallow and Alex Cox were justified under the law in killing Charles. The jury instructions tell you to use reason, common sense, and experience. Charles Vallow is dead today because this defendant and her brother Alex Cox conspired to kill him. They planned it out, and they had their weapons, and they orchestrated a way to ensure that Charles was back in the house where he was shot and killed for money and Chad Daybell. The evidence proves to you that Lori Vallow Daybell is guilty of conspiracy to commit first-degree murder, and the state asks you to hold her accountable and find her guilty. Thank you.
All right, we're going to take our 15-minute afternoon recess. I'll remind the jurors to remember the admonition. We'll resume in 15 minutes.
Well, that was a little longer than I wanted. Mark used to talk for 90 minutes straight. You should be up here on panel with me. Seriously. Whew. I need a co-host. You guys, that was a great closing. It was just a little lengthy. I mean, I think she touched everything, but there's so much to touch. I guess that's why she didn't want to leave anything out. But I'm glad that she mentioned the shoes again, because I don't know if they all caught that. And I'm glad that she mentioned that about the kids being in the car. And something that I didn't even think about was something she said earlier was she allowed her brother to bring a gun in the open with a highly autistic child in the home. I didn't even think about that. So that was really good. Mark, impressive though. You forgot to set the timer. 90 minutes with all the information. Yeah, she got it all in, but golly, that was long. I mean, like, people get so... I think they've got their mind made up even before Lori gets up there, you guys. Now, let's look back at the poll. You guys said in the poll that... oh, shoot, just had it. Now I lost it. Most of you think... 21% said that she would be under 25 minutes. Sorry, guys. I've got a little bitty space here to pull this up, and it's not wanting to move right for me. I can't see it over here on my side. Can y'all see it? I know y'all can see it. I can't see it on my end. 21%, 15 minutes. Just under an hour, 57% won. Yeah, I think she's going to talk a lot longer because she's going to testify. She's going to get up there and testify. Now, I'm going to put up the poll about what you guys think about the verdict and how long it's going to take and all that. But I want to let's let her do her closing, or at least get started on it, and then we'll go from there. What is FTW with closings? What does FTW mean, Nunya? Sue Opper is good with closings, but you know, she had a lot. Think about the number of victims and the number of, I mean, even if you just go on to that page for Daryl, and you look at all the charges that he had, I mean, you could just scroll down and scroll down and scroll down, and it's all these charges. So everybody that had to do something in that case, like as far as wrapping it up or touching on something, like we were talking about the opening statements, we were talking about the judge reading the jury instructions, and then at the end, the jury intro, or what the case intro, and then at the end, the jury instructions, and then having to do a closing on it and still touch on all of that and try to, I think Sue Opper did an amazing job at making sure that everyone, for the win, okay, thank you, that everyone was thought of in her closing, because, you know, she couldn't leave somebody out. So she had to be really clever. I wonder how long it took her to write it. You know, she spent like, I bet she started it at the beginning of the trial and kept working on it and kept working on it. And that's kind of cool. Anne said she put in her air conditioner and cleaned out a hall closet while listening. You're talking about Sue, or are you talking about now with Trina? Yeah, it was just a little long. You guys, who are they talking about that Trina was dating? Was it this Juan who was it that she's dating? She's married to another prosecutor or something. I don't know. They mentioned him earlier, and I didn't know who it was. She probably had her advisor write it. I don't know. Oh, you're talking about. Are you talking about Lori? I'm sure that she's going to take some. Wait, that's a good question. Lori has co-counsel. They can advise her. Can they help her write the closing? I think they can. They've got to be able to assist her with it, I would think. Why am I the only one that doesn't know what FTW means? Am I that out of it? Oh, wow. You all know what it means, except for me. Mimi, it was a good close, though. I agree it was. Great point, Baba. Do we think that Lori's going to cry during her closing? Because she cried during the opening room. Well, she tried to, bless her heart. She couldn't get them out because she just doesn't have any feelings. But she tried to, shed some tears there. Okay, it was Jodi Arias' state prosecutor. That's right. Okay, Juan Martinez. All right. I wouldn't mind watching the Jodi Arias case again, you guys. Because I never sat through the whole thing. Okay, thank you, Melissa. Melissa didn't know either. You don't think Blanco says no fake cry? No, she's not going to cry. Lauren didn't know either. Okay, thank y'all. Thank you, guys. Thank you, Ann. Stop it, Mark. Don't be mean to me. Now, they're married, or are they just boyfriend and girlfriend? Well, would y'all watch that with me? Would y'all watch the Jodi Arias trial with me if I would put it? Because the whole thing was streamed, correct? This was before my YouTube days, so I never got to watch the whole thing. It's been how long? I don't even remember. Another crazy one is oh God, I forgot. I remember reporting live from myself. I used to do a thing on it. You'd watch it, Blanco? It was on Court TV, wasn't it? Miss Kitty didn't know either. Mark said he'd watch a test pattern with me. You're so sweet, Mark. Oh, Brandy says she's never watched it either. Okay. Maybe we should do that, you guys. Because I was thinking, I don't really know about what trials are coming up here in between this one and her next one. What's her name's next one? And it would be fun if we did it like 3 days a week. I'll set the specific date and time for us to do them. And I'll make sure that I'm not working the other job. And then we could probably, we don't have to start them early in the morning if y'all don't want to. We could start them, later in the afternoon. And because we get to fast forward through all of the stuff, like the lunches and everything, it'll take less time to watch it. Lauren, I think you don't think it would be interesting. You love crazy women with us. You love watching crazy women. The Freeman versus Kerry trial? Or is it Kerry versus the Freeman? Because, I didn't say anything about them. They were talking about me. And to his point, and it hasn't still been, it hasn't been, I did take down those videos, by the way, but it hasn't been proven where exactly he was during that short period of time. We know where he is now, but Oscar said Oscar's wife said she'd watch it again. Okay. All right, cool. We might have to do that, you guys. Because I don't have any other stuff coming up. And the only thing about sitting here through a trial is I when I'm watching a trial, I'm not working on editing, and I edit a lot. I just like to edit. I don't like, well, like these audio playbacks and stuff that we've been watching, except for this one today. That one came straight from another stream, but I like to edit out all of the pauses and everything. I know. Well, but Sarah's just happened though. We can't do Sarah right away. We will do it again though. I honestly I was almost thinking about doing Brooks again. I was like on the cusp, but we still have to get caught up on Pam Hupp. See, that's another one I got to work on. So, but I don't know if Pam Hupp will be televised. That's the only problem. That case is, I'm not surprised they did a movie out of it. Stephen Stern's trial begins. Oh, is that the Madeline Soto? I don't know. I can't follow that one. I just can't. And do we think the mom's involved on that one, by the way, y'all? Do you think the mother knew what was going on, like he was messing with her daughter? That's just a whole new piece of crap. You know, like that's just a whole new level of crappiness for a mom to allow that to happen to her daughter or child, any child. I want to watch Corey Richards too, Bama. It's been pushed back though. We don't even know when, because now they're having to go through all this other stuff. And I don't even think it's going to start until after Lori's second one's done, probably. Nicole thinks she was definitely involved. Wait a minute. Did they say they gave her immunity? I mean, were they on her? You guys, I'm telling you, I haven't watched any of that with that case. Jen Soto was behind the camera. Oh my gosh, Melissa, you think that? Oh, it's going to be about 15 minutes. Oscar's wife for the break. The judge is usually pretty good about coming right back. That's why I'm not starting another video or anything. I don't know. I don't think I could stomach it and the details of it. And Karen Reed's been going on way too long. I don't know anything about that trial. I know, you guys, all I know is that whoever she was dating or married to was a cop, and she was charged with his homicide. That's all I know. I don't know. And I know there's a ton of details around that trial. There's a bunch of people that they think are shady. Is it because they think the cops were involved in covering stuff up? Is that what makes that case so great? I know that would be kind of fun, Barbara, but I don't know. It's hard to do. Like, it's hard to do some of them when there's so many victims involved. I bet it is confusing. Which trial did you go to, Blanco? Oh, I was talking about Crazy Women on Trial, but Boone was the only one besides the Swan Boat Club that I watch. Other women are too extra crazed. There's a couple that I have that I want to do, but it's just fitting it in. And Karen Reed starts tomorrow. Oh, well, that's perfect timing. I'll have a verdict there tomorrow morning. Said Soto's mom's not talking because she's going to testify with immunity probably. She was sleeping in the same bed with them. She sent them to sleep together. I remember hearing that. I remember, and everybody said, oh, that's so weird that she would do that. Mark says, any trial with Judge Duro. I wish we could get a good one with Duro. That would be cool. Lorena Bobbitt. Was that televised, Judy? That would be a good one because that was an older one. That was a really old one. But I don't know if we could get it to where, I don't know. That one might have a copyright on it. I don't know. I'll check though because that's a good idea. Oh, you know what? The other one that one kind of reminds me of. I don't know why I piece them together, but remember Joey Bettafuoco? Joey Bettafuoco. The Long Island Lolita. Did you watch it? Did you watch it, Laura? No one knows what is going on with Maddie's mom. All just a speculation. That's what I kind of figured. Okay, we're getting sound, so they're coming back in so the goddess can do her closing.
The defendant can proceed with her closing argument.
Ladies and gentlemen of the jury, the state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit premeditated murder of my husband, Charles Vallow. The state has the burden of proving to you that this event was not self-defense. In your jury instruction under the instruction, use of force and crime prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty. In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. Under your jury instruction titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction under presumption of innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial. We learned that a shooting occurred and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911 and was questioned by the police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the stand that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her. We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
The jury will determine what the testimony did or did not show. Go ahead.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears. We heard from several witnesses that because this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, my police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inklin that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews.
Object, Your Honor.
Or let you listen to the 911 call.
Right.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump and, according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the 3 of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all 3 of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all 3 of our cars were inside the police tape. We were directed to return later in the afternoon when the scene was cleaned up. We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective Inklin to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case, on the stand, that because of some problem, the walkthrough is not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have an evidence, any body cam footage of the walkthrough and no reports talking about it, that there are none, even though This would be crucial evidence for you, the jury, to have.
Sustained, the jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony. I'm sorry, testimony that was admitted into evidence or exhibits that were admitted into evidence.
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only 3 witnesses. So why not show the jury all the evidence that they gathered?
Again, sustained. The jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019. That law enforcement treated us that day like this was self-defense. We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind. On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
I'll sustain that objection to the extent the jury is to determine what the facts did or did not establish.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense.
No, she didn't go there.
This event was not planned or expected. It was shocking. We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was self-defense and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time, on July 11th, this was self-defense. When Tylee came out with the bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down. A 2-minute period changed our lives forever. How are you supposed to choose between 3 people you love? Your husband, your daughter, your brother?
All right, hold on. All right, I'll caution the defendant not to testify about things that were not entered into evidence.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
It's a reasonable person standard, not the standard of the person.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best things for our son with special needs, JJ. We learned in this trial that I was shocked that Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband Charles was providing for our children still at home. I had no motive to change that. We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, "We will be like Nephi." In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
Right. Sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime. When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime. And you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened. The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy. That's all.
That's all.
All right, the state does have the burden, so they have the right to open and close the argument. Do you want to give a rebuttal close? Go ahead.
She said, yes, I do. Flip that hair around, Trina. Let's do this.
Execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. Alex is involved in it because that is her co-conspirator. We are not here to determine his guilt, albeit it is quite obvious. This defendant wants you to just look at one piece, and she wants you to hope that there's only a person who will say, I saw, I heard the conspiracy. But what did you hear in every instruction is that you can look to other evidence to show that. This defendant wants you to forget about her words and pretend that when she told her lover, her soon-to-be husband, we got rid of him, that he changed the life insurance before we got rid of him, that somehow means what? That they killed him. And he changed his life insurance before they killed him. What does that tell you? That tells you motive, and that tells you who did it. This defendant is one of those we, because she's writing it. She wants you to pretend that when she is talking about Charles for months, acquiescing and agreeing to her brother killing him, having people tell her that it's wrong, having people know that they're planning something, that those words don't mean exactly what they are. We got rid of him, this defendant. The state, of course, has the burden, and that's how it should be. But every one of those justification defenses falls short when you look at the conspiracy itself. When they got rid of him, they did it by planning it. There is no reason that Alex Cox came over to this defendant's house with a loaded gun and waited for Charles to come inside, held there by this defendant using the cell phone. That is conspiracy. That is planning. That is premeditated. You can absolutely watch that whole video. That's why the state included that for you. What you're going to see is that Lori Vallow doesn't cry. She is not truthful, as we've gone through. Her timeline is absolutely wrong. She tells the detectives it's quick, it's 12 minutes. She wants you to believe that the police could understand all of this that day. But what did you hear? Is that all the police could tell initially was that the timeline was off. And then they started learning that the physical evidence seemed to be showing that Charles was executed on the floor, but they needed to see if the medical examiner agreed with them 2 days later. And then they needed to pull all those iCloud accounts, phone records, and go through terabytes of data to bring forth these things that you have now learned and hold. They interviewed these people who learned of the defendant's religious beliefs, that she was exalted, that she was celestial being, that she didn't have to repent. Of course she thought she was Nephi. We learned that the physical evidence on Charles and at the scene show us that he was executed. And every single one of those defenses that the defendant has asked you to look at, the state has met its burden. Because even if you somehow believe that Charles actually had that bat and it wasn't staged like the rest of the scene with the shoes and the lack of blood there, that second shot is not justified for self-defense, crime prevention, or third-party defense. Arizona law does not allow you to execute a man on the ground. The defendant wants you to believe she was shocked and surprised by this, and yet she goes wandering around, goes to Burger King, Walgreens, drops off her kid, comes back and jokes about her neighbors. Not one action of a person shocked, surprised. She wants you to feel bad for her daughter, Tylee. You saw her there. You heard from the detectives. She's also not shocked, crying, upset, worried. And you saw Alex. Same demeanor. Why? They've had 47 minutes to work it all out. Go through Charles's phone, figure out what they're going to say. They've talked on the phone twice in this time period. This case relies upon all of the investigation that the police did. That day, when they knew that timeline was wrong, that day when they started to understand that the physical evidence at the scene was staged and wrong and didn't match what the defendant was saying. And then all of the evidence after that, culminating when this defendant told the man that she married later that she was having an affair with, as many times as she wants to say Charles was my husband. She didn't want him as her husband. She wanted Chad Daybell. She wanted that life insurance policy, and yes, she was angry about it. And she said, we got rid of him. That is her confession to you. That is why she is guilty of conspiracy to commit first-degree murder. Thank you.
Go,
right.
Trina.
Do we have Izzy coming over? Izzy to be sworn in? All right, members of the jury, there are 14 of you, only 12 of you can deliberate. At this time, we're going to choose the alternate jurors by random lot here. So we have our scientific method here of random numbers.
14.
Juror 14.
Five.
Juror 5. I don't think you're 5. Well, maybe you are. Okay, so to the alternates, if I don't see you again, I want to thank you for participating in this process. The admonition still applies to you until we call you and tell you that it's been lifted. I have in the past had to have callback alternate jurors to testify or to deliberate when, for whatever reason, one of the jurors can't continue to deliberate, becomes sick, has a family emergency, etc. So you still could have to deliberate in this case. But again, if I don't see you again, I really do want to thank you for participating in this process. I know it might be somewhat of a disappointment to not deliberate right now, but we will keep you posted and we'll let you know if we need you. The remaining 12 jurors will retire to the jury room and begin your deliberations. First, we're going to swear in my staff.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication? And when they have reached a verdict, you will bring them back into court without revealing their verdict to anyone, so help you God.
Okay, see y'all in about an hour.
Undrop those off.
All right, to the jury.
That's what I'm thinking. If they want to not have to come back tomorrow, they're going to want to finish this up. Bye-bye. Deb said, bye-bye. Oh, we're not done. I don't know what you're saying. Good job. Thank you, all that. But let me tell you something. We're going to sit here and wait. You don't have to if you don't want to. I'm just saying, we're going to finish listening to this other audio, and we're going to hang out for a bit until they say that they're sending everybody
The jurors no longer
home.
present in the courtroom. I've passed out proposed aggravation phase jury instructions in the event that there is a verdict of guilt. The state elects to proceed with an aggravation phase of this trial. So I'll let the parties review that. It's not too long.
I could just stick on page 3. That's as a 3 in it.
Got it. All right, we'll be at recess until we hear from the jury.
All right.
All right, we are officially on verdict watch. What does that mean? That means I get to put up a banner that says Verdict Watch. All right, let's switch over to this. And I think they're fixing to play a clip on this. When we finished earlier, they were talking about playing a clip. I don't know if it was the podcast or what, but it should be interesting. And again, this is the trial in Idaho.
November of 2018.
All right, Mr. Bailiff, if we can hold the jurors for a moment, please. In considering this, I apologize for the delay. The witness is on the stand. I think it would be more appropriate to move forward at this point with your foundational questions to see where we're at, and then we'll bring the jurors in so they don't hear any of it at all if it's not coming in through any foundation. So we'll keep the jurors held for a moment. If you can start playing that, Mr. Archibald, once you get away to do that, and just long enough to ask some foundational questions for Mr. Gilbert.
Very, very good. Mr. Gilbert, I have what's been marked as Defendant's Exhibit E, and it's a recording of a podcast in November of 2018.
Objection, Your Honor. I think the defendant, or the witness would need to lay the foundation, not the defense. And the defense is feeding the information to the witness.
Okay, well, I will overrule that objection at this point, just for identification purposes of what this exhibit is, based on Mr. Archibald's proffer.
Do you remember exactly when you listened to a podcast involving Jason Mao?
Not for sure on the dates. I just know the year basically.
Okay. And what year would you guess?
2018, latter half of 2018, I believe is when they started.
Okay. And if you heard Melanie Gibbs' voice, would you be able to recognize it?
Yeah, I think so.
Thor Furuseth, if you heard his voice, would you be able to recognize it?
Yeah, I think so.
Jason Mao, if you heard his voice, would you be able to recognize it?
Yes.
And Lori Vallow, if you heard her voice, would you be able to recognize it?
Yes.
So I'm going to start this, and you, then I'll stop and ask you some more questions, okay?
I had such a powerful spiritual experience because I had a breakdown. And that breakdown led me to realize how much I needed to change my life. My heart needed to change. I was angry, I was frustrated, I had a lot of issues. And I didn't understand what it looked like.
Can you hear that?
Yeah. Yes.
Completely be accountable for self. And so as I spent a little less than a year praying and praying and praying in my closet, something happened that was so marvelous that it changed my heart forever. Filled with love from the top of my head through my whole soul. And the love was so powerful that I knew Jesus Christ could do it all. I am a testament.
And Mr. Archibald, just so you will, I know you're attempting to lay foundation here. Please don't ask any leading questions that feed the information to the witness at all in laying any further foundational questions for this exhibit.
The fire of his power.
Very good. Thank you, Your Honor.
Of changing hearts. I had a lot of pain. I suffered with a lot of pain. And when I started to feel that love, I knew there was something more that God had to offer me. And since then, I have wanted to share that message because I wanted everybody to take of it. And I believe that everybody can. It's just a decision of desire to want to and to be willing to look in the mirror at yourself and not those around you. And when you're able to do that, everything changes and the Lord will have love and mercy on you.
Mr. Gilbert, we've listened to 1 minute and 27 seconds of it. Do you recognize that?
Yes, that sounds like Melanie.
And did you hear something in the background?
Sounded like children or dogs or something like that.
And do you remember that?
I can't remember for sure, but it seems like, it's been a while.
Yeah. Okay.
And so I started a little bit writing. I just want to start off with a little bit and then I love hearing them speak. This is just a little part of a book that I started writing. It's something about a change of heart. I'm not sure what it's going to be called yet. But what I had learned from my experiences, this is a little part that I felt inspired to write one day. After going through all these things of being a victim, I had learned Melanie is a fighter and never
Your
gives
Honor,
up.
I'm
Why?
going to object at
Giving
this
up
point
means
to
unhappy.
the continuing playing of this. I think we're trying to see if the witness could identify it, and I'd ask to be able to ask some questions in aid of the objection.
All right. If you have any further foundational questions, Mr. Archibald, you can do that, and then I'll allow the state to ask questions in objection.
I could play some of each of the speakers' voices if that would help the court meet the foundational requirement.
If you want to show or play for the witness just a brief excerpt of the speakers, ask your foundational questions, and then I'll hear additional argument and objection, if any, from the state.
And Your Honor, I would actually object to him hearing the additional voices and ask if I may conduct voir dire in aid of objection.
That's overruled. This is still just foundational for the witness. The jurors are not here. I'll allow Mr. Archibald to lay foundation.
So I've had some pretty cool experiences where I've had Heavenly Father get involved in my life. Heavenly Father is the most kind, loving Father in the world. I've had experiences with Heavenly Mother. She is so incredibly loving.
Do you recognize that voice?
I believe it sounds like Thor.
Okay.
The youth battalions of the Israelites were finally allowed to enter into Canaan, and Joshua was at the helm. And their first job, their first responsibility was to purge Jericho. And the scouts went out and they saw that there were these gigantic walls and they were monstrous warriors, and this was a very difficult task. And Joshua, who had been with Moses from the beginning, and was one of, I believe, 2 people allowed to actually enter Canaan because of everybody's, that generation's disbelief.
Do you recognize that voice?
Yeah, it's Jason Mao.
It was designed to distract, to destroy, but lead.
Jesus Christ is to wake up the women warriors, because I too have gone to the bottom edge, just like Thor. I'm a witness of his testimony. I'm a witness of your testimony. I too have seen the resurrected Jesus Christ. And he has told me my mission, and he has sent me to help people and lift them in their missions. And
Do you recognize that voice?
Yeah, that Lori.
Your Honor, the witness has correctly identified the 4 voices for the first 40 minutes of this exhibit.
All right. The state, if you have any questions in aid of or in aid of your objection to the admissibility, you can at this time, Ms. Blake.
Thank you, Your Honor. Mr. Gilbert, have you ever met Melanie Gibb in real life?
Yes, once.
Only one time?
Mm-hmm.
Have you spoken to her on the phone?
Yes, we did once too, I guess.
Only once?
Yeah.
What about Thor?
No, never have spoken with him.
What about Jason Mao?
Just met him once for a minute, so.
And what about Lori Vallow?
Yes, a few times.
Have you listened to more than one podcast?
Yes.
Have you listened to other, do you know what date this podcast was made?
Not for sure. Latter end of 2018.
Were you present when the podcast was made?
No.
Do you recall what media or how you ended up hearing the podcast, what you listened to that through?
It was off a website, but I can't recall what it was.
Do you have any way to know if what you heard was altered in any way?
I guess it could have been, but I remembered it as I was hearing them, but
Have you
that
listened?
one.
Oh, sorry.
That one anyway.
And are you, just one. Do you recall the length of the podcast that you reviewed or that you had listened to?
Not for sure, but it seemed like they would usually go over an hour.
But you don't know the exact duration of that podcast?
No.
Do you have any way to know if this is in fact the exact podcast you listened to?
It sounded familiar, like I've heard it before. So
it sounded
but they had
familiar.
more than one, so I would think it'd be the same one, but I don't know.
Did you say they had more than one?
Yeah.
So you're not sure if this is the exact one?
It's one of them that I listened to, but they had 3 or 4.
Are you able to tell if this is a complete copy of what you would have listened to before?
I would think so.
Your Honor, the state would renew the objection for lack of foundation. We would also renew our objection regarding relevance. I think in listening to what as well as the objection for hearsay, the defense has represented that they are introducing this for the truth of the matter, and yet we have 3 individuals that are not here to authenticate the recording or their statements in them or be questioned regarding them. In addition, doing a quick search, and I know this is not binding on this court, but there is clear case law and there's multiple case law regarding a defendant not being allowed to present a self-serving statement. And even if there is a contention made, the state has opened the door by asking about earlier remarks. It doesn't allow for a defendant to introduce a self-serving statement. So the state would again object to any of these statements being introduced by Ms. Vallow. In addition, given the nature of the statements they intend to introduce by Ms. Vallow, we would object based on the fact that prior rulings have excluded those particular remarks. And specifically when Colby Ryan was testifying, there was certain evidence that has been excluded by this court that the defense is attempting to introduce through this exhibit as well. In addition, we were talking about beliefs represented by Chad Daybell. And again, Chad Daybell is not party or present during this recording. And so we would again renew the objection to it being presented to the jury.
All right, thank you, Ms. Blake, for the argument. Mr. Archibald, if you'd like to make any final argument in support of the admissibility of this exhibit, you may.
Your Honor, I think sufficient foundation has been laid. I appreciate Mr. Gilbert telling us the truth that yes, he's listened to this, he's identified the voices, and I'm willing to just play the first 40 minutes rather than the whole hour and 49 minutes. I believe the state did open the door to this issue with Mr. Gilbert indicating through the state's case in chief that he had listened to podcasts. So I think I think the sufficient foundation has been laid. I think the jury should be able to listen to the first 40 minutes.
All right, the court's considered the objections here made by the state to the admissibility of proposed defense exhibit E. As a starting point, I do find that this witness has laid a substantial and significant enough foundation for that hurdle to be overcome on foundation, where he identified clearly at least 3 of the 4 voices here, recalls having listened to the podcast previously. The record before the court is that the defense received the exhibit through discovery from the state, so concerns about any alterations or other inaccuracies, I think, are overcome by that. And I'll note that any of these concerns can still be addressed by the state on redirect examination as well. In terms of the contents of this, the theory of this case has delved into religious ideology throughout. It's considered one of the charged overt acts in the indictment. It's been central to the case. There, even in this podcast, a material witness who's already testified on religious issues also included in this podcast. There have previously been recorded statements of the defendant, Vallow, introduced with the jail calls. The court can consider whether or not this is just simply not to be allowed as hearsay statements, but the court would note that under Rule 803-24, there is a general catch-all provision of the hearsay rule. And in this context, I don't see this as necessarily all being offered for the truth of what's being asserted in this podcast, but more to the theory of the state as it relates to the religious beliefs of the defendant in this case and how those play into the charged conspiracy. So for those reasons, I am going to overrule the state's objection. I'll allow for the exhibit E to be admitted. And that will just be for the first 40 minutes of that exhibit. So before it's provided to the jurors in deliberation, Mr. Archibald, we need to make sure it's just a single file on the thumb drive that they get and clip off the remaining part of that podcast that would not be published today. So that'll be the court's ruling outside of the presence of the jury. That will conclude the ruling on that matter, and we'll have the jurors brought back in and you can publish at that time if you wish, Mr. Archibald.
Thank you.
And Your Honor, I apologize. Before bringing the jurors back in, I think given the nature of what's being purported to be in the recording, I guess the state would just indicate we believe this may open the door for.
All right, now that the witness has been sworn, I'll just inquire, Mr. Ryan, these trial proceedings have been streamed live on the court's YouTube channel and open for public access. Have you reviewed or watched any of this testimony that's taken place?
No.
Oh, and actually,
I was just going to note, Your Honor, Mr. Ryan is not subject to the exclusionary warrant.
I appreciate you pointing that out, Mr. Wood. That's correct. So as a statutorily definite, with the definition here, he would not be subject to that. So,
Guys, I decided to switch it over. We're going to watch Colby Ryan testify in Chad Daybell's trial instead, because I did not want to hear them talk. They were going to listen to 45 minutes of that, and we can't do that. Okay, here you go.
Disregard my inquiry. Mr. Wood, you can go ahead and proceed.
And before I do, Your Honor, may I be handed States Exhibits 6 and 4?
Yes.
Good afternoon, Mr. Ryan. Good afternoon. Can you state your name and spell your last name for the record?
Yes. Colby Ryan, Ryan.
Mr. Ryan, who is your mother?
Lori Vallow.
How many siblings do you have?
4.
Okay, can you tell us their names?
Cole, Zach, Tylee, and JJ.
And Cole and Zach, what is your specific relationship or relation to them?
They're my stepbrothers.
Who was their father?
Charles Vallow.
Your Honor, may I publish?
Yes, that's an admitted exhibit, correct?
Yes, this is States Exhibit 6.
Okay, yes, you may.
Mr. Ryan, do you recognize that individual?
Yes.
Who is that?
That's my sister, Tylee.
What is your specific relation to Tylee?
She's my half sister on my mom's side.
So you share a mother.
Mm-hmm.
Your Honor, may I publish States Exhibit 4?
Yes.
Mr. Ryan, do you recognize that individual?
Yes.
And if you need a drink of water, I don't know if there's tissues up there.
Yeah, I'm good.
Who is that?
That is my brother, JJ.
And what is your specific relation to JJ?
He is my adopted brother.
Do you recall when JJ was adopted?
Yes.
Do you know who Charles Vallow was?
Yes.
Who was he?
He was my stepfather.
And when you say stepfather, how was he your stepfather?
He married my mom.
How long was he married to your mom?
Over 10 years.
All right. And what was your relationship like with Mr. Vallow?
He was my dad. It was good.
So is it fair to say you were close with him?
Yeah.
Yeah. Do you recall when Mr. Vallow passed away?
Yes.
Or Charles Vallow? If I say Charles, we understand who we're talking about, right?
Yes.
Do you recall when he passed away?
Yes.
When was that?
July 11th, 2019.
How did you hear about him passing away?
Called me and told me that he had a heart attack.
And do you remember about what time of day that was?
Between like 1 and 3 o'clock, something in the afternoon.
In the afternoon?
Mm-hmm.
Did you have any reason to not believe or that that's how he passed away?
No.
Did you have any occasion to go over and to your mother's house that day?
Yes.
And where was that house located?
In Gilbert, Arizona.
Do you know approximately what time you went over?
And I got off at work at 7, so around 7:30, 7:45.
What happened? What was the first thing you saw when you got there?
Tylee opened the door and hugged me, and she was crying. And then I saw my Uncle Alex sitting on the couch with a bandage around his head. And then I saw my mom in the backyard, and that was it.
Did you go into the house?
Yes.
Did you see your brother JJ there?
No.
Did you speak with Alex Cox at all that night?
Yes.
How did that conversation go? What did he say to you?
Objection, hearsay.
Statement of a co-conspirator, Your Honor.
Overruled.
Tell us about the conversation with Alex Cox. Well, and before we do that, what was your relation to Alex Cox?
He was my uncle.
And you testified you saw him with something white wrapped around his head?
Yes.
Did you speak to him at all that night?
I asked him what was on his head, and he said that Charles had hit him in the head with a bat and that he had shot him in self-defense.
And is that how you learned how your stepdad died?
Yes.
Did he tell you anything else about that altercation?
No.
And did you ever have any other occasion to speak to him about that altercation?
No.
You said you saw your mother that night. And what was her demeanor?
Calm. Unrattled.
What did you think of that?
I thought it was crazy. So I was freaking out, and she seemed to not care.
And did you speak to your mother that night about how Charles had actually died?
Yes.
How did that conversation go?
She told me there was a fight and ran through it very quickly. And it was just in shock. I can't remember exactly what she said, but she just basically gave me a very quick version of the story.
Did she tell you why she had lied to you earlier?
No.
Do you remember if you asked her?
I don't remember.
Did you ever speak with Lori Vallow about Charles Vallow's life insurance policy?
Yes.
When was, do you know if that happened multiple times?
I know she'd mentioned it growing up. She talked to us about what would happen if either one of them, something happened to them, what would happen. I think it was a few weeks later that she brought up that she was not going to receive any of the money from Charles.
Okay, let's just take a quick step back. When you say a few weeks later, what do you mean a few weeks later?
After Charles was murdered.
And she told you then that she was not going to receive that money.
Yes.
From that conversation, was it your understanding that she had been expecting to receive that money?
Yes.
And okay. When Charles was alive, did you ever have occasion to speak with Lori Vallow about her and Charles's finances?
Yes.
Was that something that came up often?
Yes.
About how often, to the best of your recollection?
I would say maybe monthly, once a month.
And what was the general nature of those conversations?
From what I understood, Charles would work and then receive a bigger amount of money, and then it would kind of run out, and then they'd make another bigger amount, and then it would run out. So it's kind of the nature of the conversation would be that they were running low on money, something to that degree.
Okay. And was that a common theme then?
Mhm.
And just to be clear, the common theme that they were running out of money.
Yes.
Do you know who Tylee Ryan's father was?
Yes.
Who was that?
Joseph Ryan.
And I know that you and Joseph Ryan have the same last name.
Yes.
Was he your biological father?
No.
Okay. But did you take his last name?
Yes.
And do you know if Mr. Ryan is alive or deceased?
He's deceased.
And do you recall when that happened?
Summer of 2018, I think. Something around that time.
You don't remember the exact date?
No.
And were you aware if Tylee Ryan received Social Security benefits after Joe Ryan passed away?
Yes.
How did you learn that?
My mom told me that she would be receiving benefits.
And do you know if she received that monthly?
Yes.
Did you ever receive money from Tylee Ryan?
Yes.
How would that usually happen?
Venmo. She would Venmo me.
Okay. Would you ever ask her for some money?
I did, yes.
And about how often would that happen?
Maybe I could recall asking Tylee specifically a couple times. I would mostly ask my mom, and Tylee would be the middleman between those transactions. So I'd ask my mom, and she would tell Tylee to send the money.
Speaking of that, to your knowledge, did Lori Vallow ever send you money by sending it to Tylee, who would then Venmo it to you?
Yes.
And how did you know that?
I would ask my mom, and then she said, okay, Tylee will send it over to you.
Do you recall the last time you saw Tylee Ryan?
Yes.
When was that?
It's August 30th.
And where was that?
It was outside of my work in the parking lot.
Is that in Arizona?
It was in Mesa, Arizona, outside of a gym.
Right. And what was the nature of that visit?
My mom was very vague and said that they were leaving. She brought Tylee and JJ, and Tylee was crying and didn't say anything really. And I hugged JJ, and my mom said that they'd be back in a few weeks to visit.
Did she tell you where she was going?
No.
Do you recall if you asked?
I did ask initially.
But she wouldn't tell you?
No.
Did you receive or did you exchange text messages with Tylee Ryan on September 8th of 2019?
Yes.
What was the nature of that text exchange?
I think I had asked her to send money. And I think we had talked earlier that day a little bit. I didn't talk to her directly, but I had heard her voice and they said that they were on a trip. And I think I'd asked her for money. I think that's what it was.
Okay. And did she respond? Do you recall?
Yes.
What did she respond?
I don't remember what she said exactly. I remember her last text that she said was just I love you and I love the girls.
And you said you heard her voice earlier that day. How did you hear her voice?
She was in the background of my conversation with my mom.
Right. And did your mom tell you where they were?
She said they're at Yellowstone Park.
Did you ever have a conversation with Lori Vallow after Charles's death about Tylee's Social Security money?
Yes.
What was the nature of that conversation?
So if I recall, she said that Tylee's money was not going to be everybody's money since she
Judge,
didn't have
can I
it.
have some foundation as to what time, date, place this discussion took place?
So foundation objection, Mr. Wood?
Your Honor, I'll ask a few more questions.
Thank you.
Do you recall approximately when that conversation took place?
I don't.
Okay. Was it in person?
I don't recall. I think it was on the phone, maybe.
But it was after Charles's death.
Yes.
And just to be clear, you don't recall the exact date?
No, I don't remember.
What was the nature of that conversation about Tylee's money?
Judge, again, foundation.
Overruled.
You can answer the question.
Yeah. The initial question I had is, how are you going to take care of Tylee and JJ now? And I knew that she wasn't going to be receiving the money. So she said, we're going to supplement some Tylee money for now. And I'm going to go work. That was what she said. And that was basically the nature. But she said, we're going to start using Tylee's money to make it through. And I think that I don't know if they were receiving anything for JJ, but that was the nature of the conversation.
Okay. So you don't recall if she mentioned JJ receiving Social Security?
I don't remember, but I know about it. I just don't remember if she said that.
Okay. And do you recall if she said anything about her receiving Social Security benefits after Charles died?
No.
The last time you saw Tylee, was that also the last time you saw JJ? And I think you said that was September or August 30th of 2019.
Yes.
I want to talk to you about November 27th, 2019. Were you contacted by the Gilbert police on November 27th of 2019?
Yes.
What was the purpose of that contact?
They came to our door looking for Tylee and I think JJ as well. I specifically remember them asking about Tylee first.
Yeah. And what did you tell them?
I said I didn't know where they were.
Do you recall if you told them about the last time you had seen them?
I think so. I think so.
At that time, had you been concerned about Tylee?
Yes.
Why is that?
Our conversations were not normal. The way her dialect and her text, the way she spoke wasn't matching up. And I had texted her for her birthday and just things of that nature. Just wasn't getting calls, wasn't getting any contact in a normal way and was always avoided. So I thought maybe she was upset with me, but I just didn't want to pressure her because I know she'd been through a lot.
And so you mentioned text messages. Was there a change in those messages?
Yes.
How so?
Just little things like if you capitalize the letter I in periods and emojis, just things like that. Things just didn't sound right, and it just felt off when I was receiving those texts.
Do you recall the last time you spoke with her on the phone?
The last time I directly spoke with Tylee was on the 30th with JJ on FaceTime. So the same day that I saw them.
So you FaceTimed with them later that day?
Yes.
And then you never spoke with her again on the phone? But going back to those text messages, did you keep receiving text messages throughout September of 2019?
Yes.
And are those the messages that you felt were different?
Yes.
Okay. Did you respond to those messages?
Yes.
After the beginning of September, did you continue to receive money from Tylee's Venmo?
I think so.
Do you recall how often?
I think maybe a couple more times. So maybe 2 or 3.
And did you receive any more money from Lori Vallow?
Yes.
And how would she send that?
So she started sending money after I had not heard from her since that day. She started sending money on Cash App. I think she made a separate account and just tried to send money, and it kept denying it because it was a new account. I think it was all through Cash App at that point at just random times.
Okay. And was it in response to you asking for money, or was it just sent? Do you recall?
It was just sent.
Yeah. After Charles Vallow died, did you ever speak with your mom about her getting married again?
Yes.
And do you remember when that conversation was?
Maybe a few weeks after.
After he passed away?
After he was gone, yes.
What did she tell you about that?
It wasn't really a conversation. She just said a one-off thing like, I'll be married again soon. And I disregarded her and told her that I think that's crazy, or maybe she's talking about in the next life. It wasn't a real conversation. It was just a comment she made, and I completely dismissed what she said.
So she didn't give you any details about who she was marrying?
No.
When she was getting married?
No.
Other than soon?
Just soon, yeah.
Okay. Did your mom ever mention the name Chad Daybell to you?
I don't think so. No. I know she was becoming spiritual, if you want to call it that, for a long time, but she doesn't. I only knew Melanie. I didn't know anybody else that she was spending a ton of time with in a.
And when you say Melanie, which Melanie?
Melanie Gibb.
Okay.
Yes.
Did you contact your mother after November 27th when you were contacted by the Gilbert police?
I immediately contacted her after they left.
And what did you say to her?
I asked her what is going on. Why are the cops asking me where Tylee and JJ are? And she said, I think she asked me, like, what did they ask? And I said, they asked for Tylee and JJ. And I said, what's going on? And she just proceeded to say, I'll take care of it. Don't worry about anything. And then she's like, that's it. Like, I got it.
At that point, did you know where your mother was?
No.
So she had never told you where she was?
No. We speculated based off of the Yellowstone thing, but I didn't have an idea where she actually was.
And so you didn't know she was in Rexburg, Idaho?
No.
And she never told you that?
No.
Did you try to contact your mother on Thanksgiving?
Yes.
Did she respond to you?
No.
Did you ever have contact after that with your mother before she was arrested?
I think she sent an email not too long, maybe within a couple of weeks. And the nature of the email was, everything's fine. everything's going to be okay. Don't worry about me. I've got Jesus on my side, blah, blah, blah. But basically just saying it's okay. I've got things handled.
Your Honor, I have no further questions at this time.
All right, thank you, Mr. Wood. Cross-examination, Mr. Pryor.
Good afternoon. Can you tell me how old you are?
28.
Yeah. You mentioned a number of times that you were receiving money from Tylee and Lori. Is that right?
Mhm.
And 2018, 2019.
Yes.
Sound about right?
Yeah.
4, 5, 6 years ago.
Yeah.
Financially, is there a reason why they were sending you money?
We were just a young family and I just needed help and I was asking my mom for help.
You were a young family with children of your own?
Yes.
Okay, and just difficulty supporting yourself.
Yeah.
So your sister Tylee was helping out.
Sometimes, yeah.
And that was consistent with her character, wasn't it?
Absolutely.
Very caring person.
Very.
Very kind person.
Yep.
She was, in many ways, more of a mother figure to JJ than Lori was. Would you agree with that?
I think she was his big sister.
Right. Very caring of JJ. Very, very protective of JJ. Would you agree with that?
She loved him. Yeah.
And she understood him better than almost anybody, correct?
Sure.
He had tremendous challenges as a young autistic, 7-year-old autistic child, right?
Mm-hmm.
And of all your siblings, you would probably say that Tylee was probably the kindest, the gentlest, and the most understanding of JJ. Would that be fair?
Sure.
Yeah. Good. Now, you mentioned that Lori called you to let you know that Charles had died.
Yes.
She didn't tell you that Alex gunned her down in the house, right?
No.
She lied to you.
Yes.
That it was a heart attack.
Yes.
So you're Lori's son, natural son, right?
Yes.
So Lori Vallow lied to her son the first time, saying that Charles died of a heart attack, correct?
Yeah, there's a lot of lying in a lot of places.
And Lori lied a lot to you, right?
Other people too. Yeah.
But Lori lied a lot to you.
Yeah. And then, yeah.
And then you mentioned the name Melanie Gibb.
Mm-hmm.
Was Melanie Gibb in on this lying to you as well about covering things up?
I didn't speak to Melanie Gibb.
Okay. But Lori and Melanie were the best of friends, right?
You could say that.
Yeah. And Lori met Melanie because Melanie was teaching classes about religion and about various religious topics, and Lori gained an interest in that, and that's how that friendship started, correct?
I'm not exactly sure. She was at our Christmas party one time, and then she was there as her friend, so I didn't know what their exact connection was.
When was that Christmas party?
2018.
Okay. And the two of them were together, and it was abundantly clear that the two of them were very, very close friends, right?
Sure.
Okay. At the time that your mother notified you, you were at work, is that right?
Yes.
So did you get that message while you were actually working, or was it over a break, or how did that transpire?
So I was in the middle of my workday, and she called me, and then I went over there after work.
And where were you working at that time?
At Anytime Fitness.
Okay. And so you took a break. Do you need to take a break?
No, you're good.
Okay. You took a break, and your mother called you or texted you and said there was a heart attack.
Yes.
No mention of self-defense.
No.
No mention that Alex shot Charles in self-defense, right?
No.
She was clearly lying to her son, right?
Mm-hmm.
Okay. Now, the fight that occurred between Charles and Alex, Tylee was there and she was implicated in that, correct?
Yes.
And she was present for that fight and that entire altercation, from what you understand, correct?
Objection, states facts not in evidence.
Overruled. Correct?
From what I understand, yes.
Okay. Now, you mentioned that your father isn't Joseph Ryan, correct?
No.
But are you aware that your mother in 2018 received a sizable life insurance policy from Joseph Ryan?
I am now, yes.
You are now, like right now?
I mean, I heard that later on, yes.
Oh, okay.
Yeah.
So you're aware that financially, Lori Vallow had a significant amount of money as of middle or late of 2018, correct?
Yes.
Okay. During this time that there was discussion with Charles about financing, was it Charles Vallow who was the primary financer of the family's expenses?
Yes.
Your mother chose not to work.
She worked, I think, in the beginning, and then I think he just took over. I'm not sure. I was a child.
Okay, so when there was financial issues, it was your mother putting this all on Charles to provide for the family. Is that fair?
Yeah.
Okay. And you already previously mentioned that you communicate with Tylee at least like once a month. Is that fair, or was it more frequently than that?
Can you repeat the question? I'm sorry.
You communicated with Tylee at least once a month. Was that fair?
Growing up, or?
Well, in the last couple of years.
Yeah.
Okay, and the manner that you would communicate was by text message?
Primarily.
Okay. And how often would you communicate with JJ?
I mean, it really depends. Tylee and I would see them more often, so I didn't have much time for them not being around.
Okay.
So before that, it wasn't once a month. It was a lot more frequent. They lived in the same place and I would go see them.
Okay. And when you communicated with Tylee, or excuse me, when you communicated with JJ, it was always Tylee there, right? Usually?
Yeah.
Not Lori.
She would be there too.
Okay. Now, you mentioned that you saw Tylee on August 30th in Mesa, Arizona. That was the last time you saw them. Is that right?
Yes.
Okay. And you had mentioned that Tylee was obviously upset.
Yes.
Okay. Did you have any prior information that Tylee just did not want to go to Idaho?
No, because I didn't know she was going to Idaho.
Okay. So she was obviously upset about something.
Yeah.
And it was the day that they were packing up to leave to go to Idaho. Is that right?
Yes.
And prior to that time, there was no indication that Tylee was upset about anything else. Is that right?
I don't know how to answer that question.
Okay, that's fair. Do you remember that? And from August 30th, you then had a FaceTime call with both Tylee and JJ later that afternoon, later that evening.
Mm-hmm.
Do you know about what time that was?
Probably when I got home, so anywhere between 7 to 8 p.m.
Okay, and you don't know where they were at that point, though, right?
They were back at the house.
In Gilbert?
Yes.
Okay. They hadn't left, but they were preparing to leave.
They were leaving in the morning, from what I understood.
Was Tylee still upset about the fact that she was leaving for Idaho?
Not on the phone call, no.
Okay. Now on the back in late November, you had then had an occasion to talk with your mother. Is that right? After the Gilbert police spoke with you?
Yes.
And again, your mother lied to you again.
Yes.
Was Melanie Gibb there
Where?
on the phone? Any indication that Melanie Gibb was there listening in on the phone call?
No,
You don't know whether she was or not, or you just don't know?
I have no idea if she was there.
Okay. Now, your mother's a strong personality, right? Would you agree with that?
Yeah.
She's not someone that people can tell her what to do. Would you agree with that?
Not necessarily.
Okay. So you think she could be influenced very easily, right?
That's a big gap between not influential and influential.
Okay, but you would agree that your mother is one to speak her opinion when she has an opinion about a subject, right?
Not necessarily.
Okay. Did you have an occasion to ever interact or observe the way your mother talks to her friends, let's say Melanie Gibb, how she interacts with someone like Melanie Gibb?
Yes.
And that sort of interaction between them, your mother was a wallflower, or did she tend to speak her opinion when she spoke with her good friend Melanie Gibb?
Can you define wildflower?
Wallflower, someone very passive, who wouldn't argue, someone who would just accept the way things are.
She did not like confrontation.
Okay.
She avoided it. So take that for what it is. I don't know.
Okay, so if getting in a discussion with Melanie Gibb, she would avoid confrontation. Is that what you're telling me?
Yes.
Okay. Did she ever tell you in late November, after the police called you, that JJ and Tylee were with Melanie Gibb?
No.
Okay. Judge, I think that's all I have. Thank you, Your Honor.
All right, thank you, Mr. Pryor. Can we redirect?
Just briefly.
Go ahead.
You were just asked about kind of your mother's personality,
Mm-hmm.
Whether she was a wallflower. And you said you believed your mom had a strong personality. But that she,
I'm going to object. I don't recall that testimony.
Overruled.
but you said you thought your mom could be influenced.
Yes.
Earlier, you testified that your mom had become more religious over the years. And you were asked if she could be influenced.
Yes.
Do you believe your mother was influenced by Chad Daybell?
Objection, Judge.
Grounds.
It's speculation. There's no foundation to base what he's basing this on.
It's a question of belief. It's overruled.
100%. I think she could be influenced. Yes.
Okay. And my question was, do you believe she was influenced by Chad Daybell?
Judge, again, I'm going to object. Foundation, speculation.
Overruled.
Yes.
Thank you. Your Honor, I have no further questions.
All right. On that very last point, if you'd like, Mr. Pryor, recross. If not, we'll be concluded with the witness. And just limited to that last line of questioning you objected on, I'll allow recross.
Your Honor, I would just note, I think that question was directly in line with his cross.
Understood. I'll allow the recross.
Judge, am I permitted to go forward?
Yes, but only on that last question or two.
Now, in August of 2018, or August of 2000, excuse me, August of 2019, you had never heard of Chad Daybell, is that right?
Correct.
And you testified previously that your mother said, and please let me get to the quote. And it was a few weeks after Charles passed away, and Charles passed away in July of 2019, right? You said, I will be married again soon, but she didn't specify who she was talking about, right?
Correct.
And at that point in July of 2019, you didn't know very much about Chad Daybell either, did you?
No.
Had never even heard the name, right?
No.
And then in August, almost September of 2019, correct?
Yeah.
You had never heard of Chad Daybell. You didn't even know where or why they were going to Idaho, did you?
No.
And then we fast forward to November, 2 months later, within 60 days, you have a conversation with your mother about where's JJ, correct? And at that point, you'd never heard or mentioned the name Chad Daybell. Is that right?
Correct.
And then subsequent to that, you mentioned the fact that your mother, there was a call and a communication where your mother had been locked up. And at that point, you had a confrontation call with her. And at that point, you never heard about Chad Daybell, correct?
No, in December of 2019, there was a release, and that's how we found out that she was married.
Okay.
And that the kids were missing, and that's how we found out.
Okay. So after December of 2019, after everything started processing, that's when you drew this conclusion that Chad Daybell must be influencing her. It wasn't anything up until December of 2019. Is that fair?
I mean, they ran away together. So
Well, I understand that. But
Yeah.
prior to December of 2019, to your knowledge, Chad Daybell wasn't even in the picture. Is that right?
correct.
Yeah, I have nothing else, Judge. Thank you.
All right. All right, that'll conclude the testimony then of this witness. Is the witness going to be recalled at any point, Mr. Wood?
Your Honor, may we approach?
Yes.
Okay, let's see if this there's any more of this left, and then we'll call it for the day. I don't think there is.
All right, that'll conclude the testimony of Mr. Ryan then. Mr. Ryan, you potentially may be recalled at some point in this case. If so, you'll be contacted either by the state or the defense.
All right, guys. Well, we will be back tomorrow. I'm going to set the schedule for 10:30 Central Standard Time. Wait, no, I'm not going to do that because that would be bad. 10:30 there, 10 a.m. their time is noon my time. So I'm going to set it for noon. When I hang up here, when I disconnect you guys, it's going to take you to the stream for tomorrow. I'm probably going to change. I've got it too early. I'm going to change it to noon. So I will see you all then, okay? I appreciate you guys being here with me today. And hopefully in the morning, we'll get a guilty verdict. Y'all have a blessed evening.